Received Arup De versus Indian Oil Corporation. In deciding the case, this court formulated three issues. Number one, whether IOCL authority is bound by the principle of promissory estoppel to provide distributorship license to the petitioner. Secondly, whether the petitioner's right has been finally decided by this court by its order dated 23rd March 2021. And third issue is what rights and equities are available to the parties in this list. In deciding these issues, first issue, second issue decided against the petitioner. And deciding the rights and equities which are available to the parties, this court decides the petitioner has a right to return back the money which he has already deposited with the IOCL, and the IOCL authority is directed to refund the same amount with an interest which can be reckoned to be 6% per annum from the date of deposit to the date of actual realization. And in considering the rights of respondent number 5, it appears that the rights and equity of respondent number 5, who is the existing distributor of LPG and successfully win the legal battle against IOCL authority till Supreme Court, his distributorship license be resumed. He is entitled to start the business instantly. The respondent authority is directed to pass necessary order directions so that the distributorship license of the respondent number 5 be started as early as possible. On that score, interim order, if any, passed by this court during the pendency of the writ petition, debarring respondent number 5 to start the business is hereby vacated. Under the above observation, the instant writ petition is dismissed and disposed of. Call the next matter.
Number 80.
Very well. Call next matter.
I have to complete this program. My lord, in this matter, my lord, there is a
I appear on behalf of the petitioner. Yes.
there was a direction to file affidavit in opposition and reply, my lord.
Yes.
And in spite of that, my lord, I do not complete the affidavit in opposition, but instruction is there, my lord. For that, by this instruction, my lord, this petition maybe, my lord, your lordship can dispose of this.
You have the written instruction.
Yes, my lord. I can hand over the same, my lord, to your lordship. Now, ভাই তুমি একটা না ওকে এটা আমার ফ্ল্যাগ করা আছে তুমি এটা না একটু শেষের দিকটা একটু ইয়ে তো বড় পাতা তো একটু মনে করো
না না স্যার একদম
দেখছি দরখাস্ত করেছিল লাস্ট পার্টটা একটু পড়ে নাও লাস্ট পার্টটা তোমার কাছ থেকে my right to him and the conference মমতা রায় আর তোমার কাছে তোমার
না না স্যার শুধু আপনার
that will this will that will যেটা প্রথম করে গেছে যেটা হাইকোর্টে ফাইল করেছে ওরা একটা এ দিয়েছে বলেছে ওখানকার একটা এ দিয়েছে
ওটা একটা
বারাসাতের ইয়ে দিয়েছে যে ওখানে কোনো ইয়ে নেই কিন্তু তোমরা ফাইল করেছো হাইকোর্টে সব লিখে দিয়েছি দেখে নে তোমার মানে এর জন্য তাহলে ওই ছেলেটির কাছ থেকে এ নিয়ে নিয়েছে
আমরা চ্যালেঞ্জ করেছি বারাসাত
অলরেডি চ্যালেঞ্জ করে
যেটা করেছে সেটা আমরা আগেন্সে চ্যালেঞ্জ করেছি যে
তুমি কে?
আমি স্যার গ্র্যান্ড সান, এটা হচ্ছে আমার বাবা, সুজয় ভাদুরী হচ্ছে আমার বাবা, আর আমি হচ্ছে বিশ্বাস হচ্ছে এক্সিকিউটর অফ উইল, এখানে গ্র্যান্ড সানকে দিয়ে দিচ্ছে সবকিছু, ওর ছেলেকে দেয় না।
তুমি একটু দেখে নাও তোমার নাম দিয়ে
Lordship, in the item number 1, you delivered the judgment, my lord. There is a separate contempt application, my lord. You have to pass the another order, my lord. There is a contempt application pending before this.
All applications disposed of.
All are disposed of.
So there is a long pending dispute.
Yes, ma'am.
So what is the prayer in the writ petition?
Now, my lord,
My lords will kindly take page number 16 to 17, my lords.
it in the nature of mandamus commending the respondent call withdraw cancel the memo number auto dated auto order has been passed in connection with this said. That is in the nature of mandamus commending the respondent you to pass the order in
P9 is, my lord, the mutation order. At page number, your lordship 106 and 107.
Now what is the memo?
My lord, that is the memo number of the order, my lord. That is the reference number. Page
Memo number of
106
the
and
order of
107.
what order? Passed by the authority?
Yes, my lord.
পাতা বলো
And 106 and 107, my lord.
Page 106.
Yes, my lord.
Xerox copy.
107 is, my lord, the typed version. If your lordship kindly takes page number 107, this is the order where, my lord, the mutation was done in favor of Sri Sujoy Bhaduri, who is the son of the, my lord, the testator. While there is already a will where the testator has bequeathed his property in favor of the, my lord, the grandson. And
The
the
mutation has been issued on condition that such mutation will abide by the order passed by the competent court.
yes my lord that is probate file my lord because the
This is the observation of the mutation order.
yes my
by the competent courts.
So Sujoy Bhaduri was given the mutation 100%. Sujoy Bhaduri is the son of the earlier lessee.
Sushant Kumar Bhatt.
Earlier lessee.
that is the Original list.
Original is Sushanta Kumar Bhaduri.
Yes, my lord.
So Sujoy Bhaduri is the only son, and the present petitioner
Petitioner is the
executor.
executor. Yes, my lord.
Executor of
Executor of the
the
will.
last testament.
Yes, my lord.
So this is the dispute here.
This is the dispute. If your lordship also takes, my lord, there was, if my lord kindly takes page number 105. This is a notice from the land manager, your lordship, where, my lord, it transpires that the department, that the respondents were aware of the fact that there is a will where I am the executor and my grandson is the grandson of the testator is the, your lordship, the beneficiary. So this is the dispute. This was never considered by the respondent authorities. Now, my lord, in spite of this, my lord, the order has been passed in favor of Sujoy Bhaduri. And challenging the same, my lord, we have come up before your lordship.
Yes, Mr. Dev, what is your submission?
My lord, that is
What you
provision
want to
that, my lord, that was according to the provision, my lord. Which, yes, we should.
Unless and until probate is
When it is
granted,
granted, no order can be passed,
Yes.
my lord. That should be the order. But in this case, why this order was passed, my lord?
so what you want now?
Condition. My lord, if your lordship pass the order, my lord, that is the provision of law is that if anybody file any probate or anything else, my lord, the court, that is the respondent should wait till that. My lord, not only respondent, that the court also.
All the parties.
Your order passed. My lord, your lordship can pass in that. Yes, that is, this is not the proper way.
So what is the stage of the probate case?
Well, probate citation has been issued. We have also filed an application with discharge of the caveat. Now, my lord, what has happened? Sujoy Bhaduri has never come up before the court to contest the probate proceedings.
So probate proceeding is yet to be disposed.
Yes, my
To
lord.
be disposed. My lord,
Till the
who has
disposal
come up?
of that, my lord, this that.
So the memo is required to be set aside.
Yes, my lord, set aside. Till that. And
My lord,
after
I'll
that,
also just indicate, my lord, page
What the
103, my lord, where
এবারেই যাচ্ছে।
এটা just indicate করে দিন।
No, who is Anupam বিশ্বাস?
My lord, Anupam বিশ্বাস is the executor of the will.
তোমার
What is the relation?
He is the, my lord, mama, uncle of the grandson, my lord. Maternal uncle, yes. Sir.
And that should be the order that till such disposal of the probate case, nobody can pass any order. My lord. This is the your lordship can
So
pass.
not required to file any affidavit like.
My lord, only for that reason, my lord, I say your lordship can dispose of this matter by seeing this instruction, my lord. Only for that reason I submit before your lordship. So your lordship can pass the order.
Very good. Okay, please take down. Mr. Chandicharan De, Planet AGP, appearing on behalf of the state, submit that though there is a direction by this court to file affidavit in opposition by the state authority, but he has received a written instruction from the department containing the merit of this matter. He further submits that if the written instruction be taken note of, the instant writ petition can be disposed of. Having heard Mr. De, the written instruction be taken on record. Written instruction issued by land manager
My lord, your lordship will
Vidhannagar.
pass the order to the effect that Mr. De said so, my lord.
No,
As because this is the provision of law, my lord, for that reason
I
I
understand.
cannot want to. Your lordship can pass the order to that effect.
Very good.
That is the provision of law. I am not, my lord.
Peruse the written instruction. Heard the learned counsel for the petitioner. Full stop. It appears in a nutshell, the brief fact, in a nutshell, the facts of the writ petition is that one Sushanta Kumar Bhaduri was granted lease by the governor of state of West Bengal by the lease deed dated 22 7th of June 1973. Full stop. Possession 73 in respect of the demise premises. In respect of the demise premises. Full stop. Possession was handed over to such Sushanta Kumar Bhaduri by memo dated 20th October 1978. Full stop. During possession of the said demise premises, it is the condition of the lease deed that the said premises shall be used only for residential purpose. Full stop. During the possession of such premises, Sushanta Kumar Bhaduri had started some business in the different floor of the said building, whereby a SOCOJ was submitted, a SOCOJ notice was issued to such Sushanta Kumar Bhaduri on 23rd 11/2009. Consequent thereto, one hearing was conducted before the land manager on 28th of April 2010. Full stop. Thereafter, the reply of no, on the said hearing, reply of the of Sushanta Kumar Bhaduri satisfied the authority. Accordingly, he was allowed to continue the possession over the said premises. Thereafter, such Sushanta Kumar Bhaduri has taken NOC from the department to run different business over the premises, which was granted by the authority. Which was granted by the authority concerned. Sushanta Kumar next part. Sushanta Kumar Bhaduri expired on 11th of November 2020. One Parijat Bhaduri claimed himself as a grandson of Sushanta Kumar Bhaduri. Informed the department that a registered will was executed by said Sushanta Kumar Bhaduri in his favor, and he applied for probate of the same before the competent court. Full stop. On 22nd January 2021, one Sujoy Bhaduri, who is the only legal heir, within brackets, son of Sushanta Kumar Bhaduri, applied for intestate mutation in his favor for 100% share over the said plot. Full stop. He issued several reminders. He filed several reminders with the department for mutating his name. Full stop. On 13/7/2021, petitioner, being the executor of the last will of Sushanta Bhaduri, has informed that they have applied for probate of the said will before this court and enclosed a complaint letter lodged to the inspector in charge Vidhannagar PS Salt Lake. on 22nd July 2021, the concerned department issued a letter to Parijat Bhaduri, Bhai 1261, with request to submit copy of petition for probate filed by him before this court, and also informed about the status of the probate. The concerned department made departmental inquiry and issued a letter of confirmation of relationship certificate to the concerned authority regarding relation between Sujoy Bhaduri and deceased Sushant Kumar Bhaduri. Learned counsel on behalf of petitioner has informed the concerned department regarding the pendency of the probate proceeding before this court. However, the son of the deceased lessee, namely Sujoy Bhaduri, on 29th of September 2021, submitted an information slip contained from information slip obtained from District Court Barasat, stating that no such probate application is pending before the court. On the basis of such information slip, the concerned department has issued the impugned memo on 4th of October 2021, whereby intestate mutation for 100% share was issued in favor of Sujoy Bhaduri with condition, within bracket, within inverted comma korben, this mutation has been issued on the condition that such mutation will abide by an order passed by any competent courts. Inverted comma close quote. The petitioner has challenged the said memo on the ground that the mutation that the probate proceeding is yet to be disposed of till the till the disposal of the said probate proceeding. The order of mutation in favor of Sujoy Bhaduri is arbitrary and illegal.
My lord kindly adds that this information was intimated to the department prior to, my lord, they have passed the mutation order. Even after that, my lord,
Which
my lord will kindly take
information by the Sujoy Bhaduri?
my lord, intimation by my lord, the advocate of the executor.
Yes,
My lord,
that
my
was
lord,
I have
look at the
taken.
date.
I have
It
taken.
was prior to passing of the order. Thereafter,
Now, learned counsel for the petitioner has informed on 5th of August 2021.
it was already informed. Thereafter, even
Yes, yes.
with the information being there.
কি বললাম ওটা? Illegal. Having heard the learned counsels for the parties, also considering the written instruction and issue involved in the instant writ petition, it appears to me that the that admittedly the disputed premises was granted lease in favor of Sushant Kumar Bhaduri, who enjoyed the same till his death. Full stop. After his death, the dispute cropped up regarding on the question who would be the beneficiary in the said devised premises. Full stop. The private respondent, that is Sujoy Bhaduri, being the only legal heir within bracket son of deceased Sushant Kumar Bhaduri, applied for mutation. On the other hand, petitioner, who is a near relative of petitioner, who is a near relative of said Sushant Kumar Bhaduri,
my lord, the ex
and
Executor, my lord.
and executor of last will and testament of Sushant Kumar Bhaduri has also before the department for granting mutation in his favor. Full stop. The petitioner, being the executor of the last will and testament of Sushant Kumar Bhaduri, has already initiated one proceeding for probate before this court. The same was duly intimated to the department through the learned advocate on behalf of the petitioner. Full stop. On the other hand, Sujoy Kumar Bhaduri has informed the department on view of a information slip obtained from District Court Barasat, containing inter alia that no such probate application is pending before the learned court. No such probate application was pending before the learned court. Full stop. The department has confused and issued an order in favor of Sujoy Bhaduri with a rider that such mutation will abide by an orders passed by a competent court. Full stop. It appears to me that abide by an orders passed by any competent court. Full stop. Next, it appears that
my lord, I just indicate one thing, your lordship, just a previous line of the order. In case of any misrepresentation of the fact is ever reported, your lordship. This is also a condition that was, my lord, given in the mutation order.
full stop. It appears that the department counsel has acted upon the information slip issued by District Court Barasat. Full stop. The department was well aware that execution, that the proceeding of probate is pending before this court, not before the court of Barasat. However, the department has issued the mutation certificate, issued the memo of mutation without following the proper norms in that matter. Full stop. The department should restrain themselves for issuing of a mutation certificate if litigation is pending before a competent court. Full stop. Though the department has mentioned in the impugned order that this order would be cancelled in case of any misrepresentation of fact, misrepresentation of fact, but it appears that the Sujoy Bhaduri, that the private respondent has already placed information slip of a court where no probate proceeding was pending. Full stop. Consequent thereto, the impugned order passed by the department, impugned mutation order passed by the department on 4th of October 2021 appears to be on the basis of misrepresentation of Sujoy, appears to be on the basis of misrepresentation by Sujoy Kumar Bhaduri Thus, the impugn order is illegal and is hereby set aside. Full stop. It is clarified that the department must not proceed to issue any mutation order in respect of the devised premises till the disposal of litigation stroke probate proceeding pending before this court. Full stop. Under the above provisions, the instant writ petition is disposed of.
Deeply obliged, my lord. Ah. My lord, there has been a passed over matter. My lord, should I just come back or something?
No passed over matter? What
Six,
matter?
item number 6, my lord.
Yes.
Great. My lord, I am for the petition on this matter. My lord, there has been a report, my lord, that has been filed by the state.
Which matter you're pending? 11, 12. Okay, just let me hear it out. I could not follow it. Yes.
My lord, there has been a report, my lord, that has been filed by the state here. So, my lord, the prayer before your lordship was that there was a land acquisition process for which I was never given with the compensation. And my second prayer was to provide me with a land loser certificate so that I can apply for the employment. So, my lord, I made this representation, the petition, this report that has been filed by the state, where, my lord, it is disclosed that yes, the compensation is not paid, and that is because of the reason that I did not produce the pradhans or the councillors certificate as to the heirship, legal heirship. So if that could have been produced, then it could have been, my lord, issued to me. So that this is why this has not been issued since 1992, they say. And, my lord, they did not even intimate this, that this was the reason for which it could not be paid in your favor.
Is it in the report?
This is in the report.
So what you want now?
So, my lord, I can immediately produce this certificate. So, my lord, if your lordship want, I could have just prayed before your lordship for consideration. If my lord senior for the other side was
Yes,
present,
who is appearing for the state?
my lord, Mr. My lord,
Call him, I can dispose
yes.
so that I can dispose of this matter today.
or my lord, if I just could pray before your lordship that I bring that, my lord, particular certificate by the municipality on record, and so that, my lord, they take that thereafter, my lord, take the steps for disbursement instead of, my lord, forwarding them to the
However,
department.
you have to place this before the authority, not
And I
before
can
this
easily
court.
do. Of course, my lord. Of
So
course.
let the person appear for the state. Who is appearing?
My lord, my learned senior, my lord,
Anjo.
but the report that has been filed, I see in the back sheet the name of my learned senior, my lord, Mr. Supratim Dhar.
Okay, you call Mr. Dhar, I will pass the order.
My lord,
You call Mr. Dhar, I will pass the order.
great. Great.
Next, Mr. Dhar is there.
Oh, দাদা ওই একটা রিপোর্ট দিয়েছো, এটা তোমাদের রিপোর্ট, যে রিপোর্টে বলছে যে আমি সার্টিফিকেট জমা দিইনি লিগ্যাল হেয়ারশিপে মিউনিসিপ্যালিটি বা পঞ্চায়েতের থেকে, তাই জন্য কম্পেনসেশনটা পাইনি। আমি বলছি যে আমি সার্টিফিকেট চাইলেই দিয়ে দেবো। সেই জন্য জজ সাহেবকে আমি বলছি আমি অ্যাকর্ডিংলি ডিসপোজাল যদি করেন, গ্রান্টিং মি
Is it the only embargo?
দ্যাট ইজ দি, এই যে তোমার রিপোর্টে সেটা বলা আছে। পরে দেখো তো।
Sujit Bari.
পরের পেজটা দেখো, এখানটা দেখো, তারপরে এখানে।
80% ad hoc পেয়েছো?
আমি হচ্ছে অনাদি বাড়িকে ছেলে মেয়ে।
Further, the final award was duly prepared in the manner.
নন সাবমিশন অফ অঞ্চল প্রধান সার্টিফিকেট।
Can't be.
No, Mr. Dhar, in form 13A is there. What you were saying on the yesterday,
Yes.
that is the portion and the share, everything is there. You can see it
Yes.
in your report. That is in Abdul Barik, page 15A.
43 এটাই তো
হ্যাঁ।
অ্যাওয়ার্ড সিরিয়াল নাম্বার 43 at page 12
Onadi Barik, my lord. My
Page
father.
12.
at page 12
Onadi.
Barik.
award serial number 43. Share is there as also against each person. What would be the amount? That is also there. On top, brought forward 28,315.
Thereafter, Sotero Gonda, like that. Says
Yes.
there.
Yes. So let them go before the authority with their legal heirship certificate.
If this is the only embargo or anything is there, or you can come later on.
From the report itself, my lord, it is evident because of
Kothay?
this.
Only
heirship
this
certificate.
issue.
Only this one.
Control
And
for our certificate.
I was, my lord, see,
How only this issue you are devoured for?
and if I would have, my lord, at least intimated that this was the issue for which it is not being disbursed on your favor, I could have easily done it, my lord, long back.
Or it happens
Abdul
on
Barik.
several occasions. Authority has faced with this kind of a problem where 5 legal heirs, only 2 legal heirs
To receive the entire.
entire sum, and thereafter authority is in problem, my lord.
If that be the only issue, I can pass
My
the
lord.
order right now.
Yes, my lord, that is the only issue.
Okay. So
There is no other issue.
Abdul Barik is your predecessor.
Onadi Barik, my lord.
Onadi Barik.
Onadi Barik.
Onadi Barik is
এছাড়া
your
তো
predecessor.
কোনো নন ভেরিফাইড এর আর কোনো কারণ
26
নেই।
paisa,
হুম।
60, 26 rupees 60 paisa.
Yes. My lord, kindly seize my. Acha. My lord, I tell your lordship. My lord, petitioner number 1 is the son, and petitioner number 2 is the mother. Means, my lord, the wife of the.
You mention me the paragraph of report where they have said that only the
এটা দেখুন
legal heir
না।
certificate is missing.
Lordship. একবার দেখি দাদা।
হুম।
My lord, page number 4, clause number G.
G. Non-submission of Anchal Pradhan certificate which
That is the noting on the even on the left hand side. ওই জায়গাটা দেখাও।
So it would
Annexure
so it
page.
is the municipality, my lord. So it would be, my lord, municipality's certificate now.
whatever maybe the authority
Yes.
who is
Local authority
legal heir certificate.
And my lord, my second prayer, issuance of the certificate of land losers category.
Land losers, whether it is available, who is the requiring authority?
My lord, I tell you, lordship. This recording authority, my lord, was
Kindly at page 17,
recording authority.
form number 7 বলছি ততক্ষণে দেখতে থাকুন
Yes.
applicationটা দেখে। On the left hand side, name of the village, মানে on top there are few columns. On the left hand side, number of plot and then name of village. Under that, kindly come.
Yes.
These are the Barik families, and stop because certificate is required.
Okay, I understand.
And my lord, the recording body is, my lord, the railway, because it says for the Tamluk Digha VG rail line for the purpose of that project.
You applied before the authority. Have you applied?
Yes, my
Have
lord,
you filed any representation?
I did that, my lord. If I request your lordship, my lord, to see, my lord, the last representation, I have been making representation. The last your lordship will see at page number 42.
ওনাদি মারা গেছে।
42.
42.
Yes. To the chairman railway board.
Yes.
Whether railway board is a party here?
My lord,
No.
the chairman railway board, I have made representations to all of them, including the district magistrate, the acquisitioning body,
Now, whether railway board is the party here?
because since
Union of India and General Manager Southeastern Railways
they are
are
always
party,
our party.
but not the board
Yes,
or
board-
chairman of the board.
Point number 1 and 2 are there before your lordship. They are the railway board.
Union of India service through chairman railway board.
The next respondent.
Who is appearing?
I have served, and the affidavit of service is it in your lordship's record. Or the land loser certificate subject to correction of my land senior. Land loser certificate would be issued by the acquisitioning body.
Acquisition body?
Yeah.
By the states?
Yes.
Okay. So respondent number 3 is the authority, district magistrate Puru, and
Yes. Yes, madam.
to consider the
Subject to
representation.
correction, Yes.
Yes.
Whether
Till the there was a direction, there was a geo till the one committee has to be constituted in respect of every district. Till the committee is not formed, the district magistrate is the authority to issue the land loser certificate.
if the committee has not formed yet.
জাস্টিস পার্থসারথী সেনের একটা রিসেন্ট জাজমেন্ট আছে,
Hello.
একটু ওটা ওটা দেখো না, সেখানে দুটো জিওর কথাও বলা আছে।
Okay, let come with that geo. So can I can pass the order.
Well, Justice Sen has dealt with this issue, and there was supposed two geos. Subsequently, no committee was formed in that particular district. Hence, Justice Sen has directed the
But yeah.
concerned DM.
So it could be done, madam, subject to.
আগে অর্ডারটা বার করে দাও, তাহলে
ঠিক আছে।
Yes, that will be proper. Otherwise, okay. So come next week then.
As your lordship.
Please take down. Matter heard in length
দাদা তুমি জানিয়েছিলে কি তাহলে আমি
from the learned counsel, Mr. Thor,
Yeah.
appearing on behalf of the state, as well as
পার্টির নামটা আমার মনে
Mr. Roy, appearing on behalf of the petition. Concerning the
land
subject,
closure certificate
matter made ported.
এই তিনটে মারো।
Let the matter appear in the list on 17th
Grateful.
under the same heading for further hearing.
I'm deeply
আপনি সবগুলোতে আছেন।
Theatre.
But I am for the, I can. Ask, I can. Yes.
My lord, I appear on behalf of the petitioners, my lord, in item number 11 and respond number 8.
Good, my God, I'm happy. For this, I need to call my friend. So for the item number 12 is concerned. So for the item number 12 is concerned, I appear on behalf of the petitioner, my lord, first my lord, item number 11 to be heard, then my lord,
Item number
My lord.
12. Item number 12. Title.
My lord, I appear on behalf of the petitioners, my lord, in item number 11.
Yes, what is the matter about?
My lord, the petitioner number 1, before your lordship, initially, my lord, initially petitioner number 1 was inducted as a tenant in respect of premises number 21 Chetla Central Road. My lord, subsequently that, my lord, premises was purchased by the petitioner number 1 pursuant to the enforcement of, my lord, the, my lord, agreement and passed in a decree in a suit. My lord, so, my lord, the petition number 1 has become owner in respect of that premises. My lord, initially, my lord, one Pranamananda Bose, he was the original owner in respect of the entire premises 21 Chetla Central Road. He was the original owner.
Yes.
And, my lord, 3 brothers, they have, my lord, separate joint property in respect of, my lord, other 2 premises. My lord, they filed a statement under section 6(1) of the Urban Land Ceiling Act. My lord, that after filing that, my lord, statement, my lord, draft statement was served upon the original owner. And to that draft statement, objection was filed by the respective owners, and that objection was considered. And after considering the objection, order was passed by the competent authority. Your lordship, kindly come to the order passed by the competent authority. That starts from, my lord, page 40. Your lordship, kindly come to page 40. annexure P2. That is the certified copy, my lord. You will also kindly come to
Page 40.
page 40, P2, annexure P2.
Page 40. Order of hearing of objections
Yes, order of hearing of objection.
under
That
section
is the-
8.4.
Yes. My lord, you will also kindly come to, my lord, relevant, my lord, premises that has been dealt with in the order. You will also kindly come to page 46. 46. I am concerned with the premise number 21. May I place that order? My lord, 21 Chetla Central Road. Land at the premises is owned by Sri Pranavananda Bose in 16 Anna share. In his statement under section 6.1, Pranavananda Bose included these premises as land with structure. In the site plan attached with the statement, as many as 17 RT sets were shown. Sri Bose wanted to lease out the land and appealed under section 27 of the Act. In the draft lease deed furnished with the application, it was stated in the schedule of the property that there are only one tile sheds on the said land supported by site plan. A local inquiry was held. It was found that a temporary structure measuring 10 square meter only was existing. The structure was constructed without approval of the Calcutta Corporation. It was ignored. The application for transfer was referred on the ground that it was the excess vacant land of the transferor. There is a lot of difference between the claim in section 6.1 statement and the site plan attached thereto. And in the application under section 7.2, affidavit, draft lease deed, and the site plan furnished with the application. At the time of hearing of objection, a different point one on new land has been made out. It is claimed that this piece of land is land appertaining to premises numbers 19 Chetla Central Road, which is said to have having as many as 5 dwelling units. It has already been discussed in connection with objection in respect of premises number 14 Pyarimohan Road, that land appertaining to a building cannot split over to another premises, and the same logic applies here also. Moreover, there are some other facts which are relevant here. Premises number 19 Chetla Central Road belongs to exclusively to Santosh Kumar Bose, as we got from the 6.1 statement and site plan attached thereto. Sri Santosh Kumar Bose, whereas premises number 21 Chetla Central Road belongs to exclusively to Pranavananda Bose as mentioned in his statement under section 6.1. Neither Santosh Bose did anywhere in his statement mention that he had any claim whatsoever on 21 Chetla Central Road, nor did Pranavananda Bose give any indication in his statement he had interest 19 Chetla Central Road. It is now clear that there are two premises belong to two separate persons. Naturally, land appertaining to building owned by one person cannot be at a premises owned by a different person. How the copy of the statement assessment book of Calcutta Corporation can show Pranavananda Bose as a owner of premises number 19 appears to be strange. In the affidavit filed by Pranavananda Bose in connection with the application under section 20, it has not stated that he was holding premises number 19 also. Again, Santosh Bose in his statement mentioned that structure at premises number 19 is a non-residential one. The copy of assessment book shown a transport agency is the occupier collectorates this. Thus, the house has therefore been constructed later on. Hence, land at premises number 19 should also be treated as a vacant land. Therefore, the objection with regard to 21 Chetla Central Road fails. It has correctly assessed as vacant land. So, my lord, it was after considering the objection, it was decided and declared that it was a vacant land. And my lord, order was passed. Against this order, appeal was filed. Your lordship kindly come to page my lord 66.
Who preferred the appeal?
Yes, my lord, this Pranavananda Bose preferred the appeal. 3 separate appeals were filed by the brothers.
Pranavananda Bose has filed this objection.
He filed the objection. After considering the objection, this order was passed. That order, my lord,
Objection of what? 8-4. Objection under 8-4.
yes, that was considered and final order was passed. Your lordship kindly come to that. The order was passed on 23rd of July 1980 at page 52. The last
Page
Last-
52.
page 52, last part. Draft statement have been altered. Final statement under section to be prepared. This altered draft statement.
Yes.
But order dated 23rd of July 1980. Order against this,
Preferred appeal.
yes, appeal was preferred. Your lordship,
Page
your lordship kindly come to page my lord 66.
66.
These appeal, my lord, 3 appeals were filed. This appeal were dropped. You also kindly come to the my lord paragraph. I am direct to refer the above noted appeal case and to inform that these order dated 3rd December 1980 to the Special Secretary, the Department Appellate Authority has dropped the proceedings. The appeal number my lord 46, 47 and my lord 72. These 3 appeals were filed against that order. My appeal is my lord in respect of 21 my lord Chetla Central Road, appeal case number 47.
Appeal case number 47 of 1981.
Yes. That is my appeal and other 2 appeals 46 and 72
Yes.
in respect to other premises. My lord, against this order, my lord, writ application was filed before this honorable court. Your lordship kindly come to next page 67.
Okay.
Interim order was passed by my lord Justice Manoj Kumar Mukherjee, his lordship then was, and thereafter final order was passed. Your lordship kindly come to page my lord page my lord 73. Annexed P5.
Yes.
10th of February 1986. Order was passed by my lord Justice Bhagavati Prasad Banerjee, his lordship then was. Your lordship kindly come to page 74.
Read from 73, second paragraph, considering the facts and circumstances.
So it starts from 73.
Yes.
My lord, it's my lord, relevant my lord part. I am my lord placing 75 is the ordering portion. '75. Considering the facts and circumstances of the case on the bottom, at the bottom, my lord, paragraph. 75, sorry, 73. 73. I am sorry, my lord. Considering the facts of the case, I think that when the proceeding under the said act had been dropped in the event, it was obligatory on the part of the respondent to cancel, revoke, or rescind the order which is being annexed B to the petition. In the result, the rule is made absolute, and the respondent are direct to cancel, recall the order vesting, which is annexed B, to the petitioners consequent upon the draft of the proceeding for vesting, let the writ in the nature of mandamus do issue, commanding the respondent to issue an order cancelling of the order of vesting, which is annexed B to the writ petition. One annexed B that I place the order passed by the my lord competent authority, order dated 23rd of July 1980. That was my lord
Order of vesting.
order of vesting.
Yes.
My lord, against this, my lord, this order, my lord, the respondent authority, they filed, my lord, application for, my lord, recalling. At the recalling order, they have annexed in their, my lord, affidavit in opposition. Your lordship kindly come to their affidavit in opposition. Order of recalling was first order of recalling was filed, and thereafter again an application was filed for clarification of the order. Your lordship kindly come to annexure PR2, page 27 of the affidavit in opposition filed by respondent 1 to 4.
Yes.
Page 27. Annexure R2. First recalling application was filed, thereafter, my lord. May I place the order? The above application, this is a order passed on an application for clarification. The above
You
application
are
was
reading page
page 27. The type copy of the order, my lord.
27.
Their opposition. Opposition filed by respondent 1 to 4.
1 to 4.
Yes.
Page 27 is the last page of the order.
My lord, 28 is the last page in my brief, my lord. 27, annexure R2. For us, this was reconstructed. Reconstruction. That's why it can.
Okay.
They had filed an affidavit which was not the record. Honorable Justice Vikas Patnaik, when he was hearing the matter, he directed the state to
Reaffirm.
reaffirm. It is
So you may,
there is hardly any difference. There is no difference at all.
it may not tell you, my lord, yours in my brief.
31 of the reaffirm.
Reaffirm.
31 of the reaffirm. Your Honor, take that.
Order dated 28 June 1987. My lord, page 31, your lordship, kindly, your lordship, maybe.
Application for clarification the order.
Yes, that is the.
Okay.
The above application was filed by the respondent number 5 for clarification of my order dated July 21, 1986, passed in the above rule. In this case, it appears that by order dated February 10, 1986, well, just I placed that order. The above writ application was finally disposed of and was made absolute by an order and judgment passed by me. Thereafter, by order dated July 21, 1986, I passed an order by which I made it clear that the said order passed on February 10, 1986 would not prevent the respondent to proceed against the petitioner in accordance with law. It is admitted position, and from the application it clearly appears that an appeal preferred and the said appeal is still pending. Accordingly, the order passed by me earlier is clarified to the extent that the appeal filed under the provisions of the Urban Land Saving Act should be proceeded with, and the said authority will dispose of the said appeal pending before him as expeditiously as possible and not later than 3 months from the date of communication of this order. The above application is disposed of accordingly. So, clarification order was passed on, my lord, 28th of June 1987, clarifying the order that appellate authority may proceed with the appeal and should be disposed of within certain time. My lord, thereafter, appellate authority passed an order that has been annexed with the rejoinder filed by the respondent 1 to 4. Your lordship will find their rejoinder. Page 11, annexure R2, page 11. That is the order of the appellate authority. Final order was passed. I am not placing the entire order. I am placing the, my lord, operative part, page 22.
Page
22. I accordingly,
this is the order of appeal.
yes, order passed by the appellate authority on page 22 of the rejoinder.
Very good. Yes, proceed.
Operative part I am placing. It starts from page 11. I accordingly find, although all the contentions in the appeal petition and oral argument cannot be accepted in toto, the competent authority Calcutta has not acted in accordance with law in determining 2,524.6 square meters of land at premises number 1, Dwarikanath Ghosh Lane, 14 Pyarimohan Rai Road, 16 Jainuddin Mistri Lane, and 21, this is my lord premises, 21 Central Chetra Central Road and 3/1A Nafar Kundu Road, Calcutta, to be excess of the ceiling limit of the appellant and hence liable to be surrendered by the appellant. In the result, the appeal succeeds. The final statement issued by memo number such and such is set aside. Notification under, this is very important, notification under section 10(1) and section 10(3) published in the Calcutta Gazette, Extraordinary Gazette, dated March 30, 1983 and July 1, 1983 are also set aside in the circumstances it is ordered. So both the notifications and, my lord, the appeal was allowed, and the notification published in the Calcutta Gazette, that was set aside, and ordering portion, your lordship kindly consider that the appeal is allowed on consideration of merit. The competent authority Calcutta is directed to prepare a final statement on the basis of 651 square meter of excess vacant land at premises number 1, Dwarikanath Ghosh Lane, 273.05 square meter of excess vacant land at premises number 66, Jainuddin Mistri Lane, 208.96 square meter excess vacant land at premises number, this is my premises, 21 Chitla Central Road, and 343 square meter in excess vacant land at premises number such and such, and issue a fresh notification accordingly and take subsequent steps towards vesting of the excess vacant land in accordance with law. This is the order of the appellate authority, setting aside earlier notification and the order passed by the competent authority. Everything was set aside and only directed to, my lord, prepare a final statement and, my lord, to issue a fresh, my lord, notification under section 10(1) and to proceed in accordance with law. My lord, now your lordship kindly come to, I have challenged the two notices issued by the, my lord, the competent authority. My lord,
Subsequent notices
yes,
after the pass of the appellate order.
after passing the appellate order, my lord, they issued a notice to the petitioner number 1 to vacate the premises without following the, my lord, without considering the order direction passed by the appellate authority and without complying with the provisions of the law under section 10(1) and subsequent. May I place the, my lord, the notice
Yes,
which was issued by the authority? Your lordship kindly come to page 93. Page 93 annexure P10.
93 of writ petition.
Writ petition. may I place the letter? My
Yes.
letter dated 4th of June 2015. My lord, with reference to your above mentioned application for NOC, the undersigned would like to inform you that on the basis of 6-1 return filed by Prananda Bose, proceeding was drawn under section 10, 8 to 10 of the Act, and the same was completed up to the stage of section 10(3) Gazette notification declaring the quantum of land measuring 802.96 square meter as excess in premises number 21, Chetla Central Road, held by Pranavananda Bose. It further appears from the document submitted by you in NOC application that you have purchased the said land over the premises number 21, Chetla Central Road, from the said returning, Pranavananda Bose. Such transfer is unlawful under the Urban Land Selling Act, as the said Act said already been declared excess under the Urban Land Selling Act. So you are direct to deliver possession of such excess vacant land to you immediately. This is a notice under section 10(5) issued by the authority. Is enclosed herewith. Notice has been enclosed. That has also been challenged. My lord, section 9, page 94.
This is the notice.
The next page, my lord,
Next
94. This is the notice. Notice under subsection 5 of section 10. This is the notice issued.
Quantum 4802.96 square meter.
Yes. So I have challenged this notice on, my lord, 2 grounds. And thereafter another notice that was issued at page 96. That was issued by the, my lord, EIT. They requested to deliver vacant possession. So these 2 notices I have checked. My lord, on 2 grounds. First, my lord, your lordship kindly, just now I placed the order of the appellate authority that all the, my lord, notifications issued by the, my lord, competent authority that was set aside. Order of the, my lord, the competent authority that was set aside in appeal. Only there is a direction by the appellate authority that a, my lord, final statement under section 9 will be, my lord, third, and the proceeding under subsection 1, section 10 will be, my lord, followed by the authority, and subsequent, my lord.
They have followed the order. Only
No, 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 no.
80296 square meter was
No,
estate.
my lord, Gazette notification was not published. After this, my lord, order was passed, my lord, direction was given by the authority on, my lord, 16th of November 1988. No notification, Gazette notification was published according to the order passed by the authority. Gazette notification in the Calcutta Gazette. That is my specific case. Let them show any notification was published after this order was passed in the Calcutta Gazette. No notice was published. My dear lordship, kindly come to their affidavit. What they have, my lord, stated in their affidavit in opposition. Yes. Affidavit filed by respondent number 1 to 4.
Yes, proceed.
Their affidavit, I do not know whether, my lord, it will tally with the page. My lord, paragraph 8.
Paragraphs are okay.
The list is contained 5 to 8. It starts from, in my, my lord, read page 13, paragraph 8. 39. That the allegation and the contentions made in paragraph 5 to 8 of the said petition are specifically denied and disputed by me, as if the same are set out and traversed ad seritem. It is stated that on the basis of the statement under section 6(1) of the Act, draft statement under section 8(1) of the Act were prepared and served upon the returnee inviting objection, if any, within 30 days from the date of receipt thereof. Objections under section 8(3) of the Act against the above draft statement were filed, which were heard, and reasoned order were passed under section 8(4) of the Act on July 23, 1980 by the competent authority, Kolkata. An area of land measuring 2,524.60 square meter, 2011 and 0.82 square meter and 1378.23 square meter were declared excess vacant land held by Pranand Bose, Sudhir Bose, Santosh Basu, respectively. Final statements were prepared accordingly. Third, upon the returnee. Notification under section 10(1) of the Act was published in the Calcutta Gazette on March 30, 1983. This is very important. Subsequently, declaration under section 10(3) of the Act was published in the Calcutta Gazette Extraordinary on July 1, 1982. As a sequel thereto, under section 10(5) of the Act was served upon the returnee to give possession. This is, my lord, very, my lord, important. All these notifications were set aside by the appellate authority. Being aggrieved, the state returnee appeal was filed, my lord, thereafter. So, the possession notice that was served under subsection 5 of section 10, my lord, upon the returnee, they have stated in their affidavit, these notifications are all are set aside. When it was served, it was not given.
Yes.
So my submission is this, my lord, that after the order dated, my lord, 16th of November 1988 was passed by the appellate authority, and direction was given to, my lord, follow the procedure laid down under subsection 1, section 10 of the Urban Land Selling Act. My lord, no gazette notification was published, my lord, in the Calcutta Gazette, and no gazette notification was published under subsection 3 of section 10 as required under the Urban Land Selling Act. My lord, may I place the, my lord, section, my lord, 10(1) first. It was the direction of the appellate authority that this should be, my lord,
What is this?
Urban Land Selling Act. Acquisition of vacant land in excess of selling limit.
You are reading section?
Section 10, subsection 1. Section 10.
Yes.
As soon as may be after the service of statement under section 9 on the person concerned, the competent authority shall cause a notification giving the particulars of vacant land held by such person in excess of the ceiling limit and stating that such vacant land is to be acquired by the concerned state government and the claims of all persons interested in vacant land may be made by them personally or by their agent, giving particulars in the nature of their interest in such land to be published for information of general public in the official gazette of the state concerned and in such other manner as may be prescribed. So, according to the direction of the appellate authority and also under subsection 1, section 10, my lord, the notification has to be published under the Calcutta Gazette. There is no such, my lord, publication made by the, my lord, authority. Well, why this provision has been made? Your Lordship, kindly, the claim of the persons interested are to be considered. Next section, subsection 2. After considering the claims of the person interested in the vacant land made to the competent authority, my lord, unless the publication is made, my lord, in the Calcutta Gazette, my lord, public will not, my lord, person interested will not know. And after considering their objection, that is section subsection 2, after considering the claim of the person interested in the vacant land made to the competent authority in pursuance of the notification published under subsection 1, the competent authority shall determine the nature and extent of such claim and pass an order as deemed fit. So order has to be passed. After publication, they will file objection, and objection will be considered by the authority, and order will be passed. And next, my lord, kindly come to subsection 3. Not only that, my lord, 2 times publication has to be made in the official gazette. First, my lord, inviting my lord under subsection 1, and thereafter subsection 3. Declaration has to be made, that has to be published in the Calcutta Gazette. Both these provisions has not been complied with. And straightway, my lord, the notice under subsection 5, under section 10, my lord, has been issued to the, my lord, the petitioner. Your Lordship, kindly come to subsection 3. This has to be, my lord, followed. Thereafter, my lord, subsection 5 will come. My rule 6, your Lordship, kindly come to rule 6.
Yes.
Kindly come to, my lord, subsection 3. As my lord gone through that, my lord, first, my lord, publication under subsection 1. Then under subsection 3, there must be a publication under the Calcutta Gazette. At any time after publication or notification under subsection 1, the competent authority may, by notification published in the Calcutta Gazette of the state concerned, declare that the excess vacant land referred to in the notification published in subsection shall, with effect from the date as may be specified in the declaration, may deemed to have been acquired by the state government, and upon publication of such declaration, such land be deemed to have been vested absolutely in the state government. Unless this declaration is made, this land has not been vested, treated to be vested land. This is the land of the, my lord, the owner. So government, my lord, has no, my lord, authority to, my lord, vacate, to, my lord, ask the, my lord, petitioner to vacate the premises, unless this is vested. Till date, he is the owner.
Okay, this is only the issue here.
This is the, my lord, only issue.
No notice under section
No,
10(1) or 10(3).
Yes, no notice under, my lord, subsection 1, section 10, as required under the law, and also directed by the, my lord, appellate authority, has been, my lord, complied with. And subsection 3 also, that has not been complied with. It will not appear from the affidavit that they have published, my lord, the Gazette notification as required under subsection 1, section 10, and subsection 3 of section 10, and also as directed by the appellate authority. Only they, my lord, final statement was published. That has been, I have annexed that. They have. Your Lordship, kindly come to Rule 6 of the, my lord, urban land saving rules. How it is to be, my lord, through manner of publication or notification giving particulars of vacant. Rule 6 provides that. Perhaps in that book rule আছে, বইটাতে rule 6 আছে, as my lord got the rule 6.
You are referring rule 6.
Rule 6. The manner of publication of notification giving particulars of vacant.
No rule. Repeal. Yes, rule is not there.
Yes, yes, kindly come.
You read it, read it. You just read it.
And I have book, my lord, yes, kindly. Yeah, kindly.
Yes.
As my lord gone through that.
Yes, I have read it.
So, my lord, my submission, my lord, that is my only, my lord, point that subsection 1 of section 10 that has not been complied with, and subsection 3 also that has been complied with straightway, my lord, without complying of that two provisions,
They come to 10.5.
they cannot. And from their affidavit, it will not, they have not stated anything that notification under subsection 1, section 10 has been published in the Calcutta Gazette, and subsection 3 also published in the Calcutta Gazette. It will not appear from the affidavit.
That's all.
That's my comment.
So far the item number 12 is concerns. So my learned submitted the item number 11. So my lord, the facts of the case of the my lord, so far the item number 12 is concerns. Appellate order, which has been passed by the appellate authority. I have challenged before this honorable court. Initially, my father was filed the writ petition. So during the pendency of the writ petition, my father expired. Now that
No, against the order of appellate authority,
1988,
which was shown by the learned counsel.
my learned senior friend. So now, my lord, so far if
Who are
the
you?
appellate authority's order is goes. So there is, my lord, the twofold submission before your lordship's two grounds.
Just wait, just wait. That is the order of appellate authority.
So my lord, is the appellate authority orders. Kindly come to page in my petition. Can come, my lord. It's 1988. So my lord, that has been annexed. Appellate authority noted upon the decision of the 16th of November 1988, page 82. Annex. Eta not is the my lord the first writ petition.
Yes, got it.
Got it, my lord.
So who are you?
So my lord, initially my lord, I am the landowner.
Landowner of what?
21
Uh,
Chedla Road, that is my lord. He is the my lord, the second writ petition is the subsequent purchaser.
in respect of which plot?
My lord, the 21 Chedla Central Road, which is under
21 Chitra Central. Road.
Central Road. So now my lord is
So
the
the petitioner in the item number 10 is the subsequent purchaser. You are also subsequent purchaser.
no, I am the owner, he purchased from me.
You are the owner.
So now the crux of the case is before your lordships, my lord, my lord, the Urban Land Ceiling Regulation Act has come into force in my lord, the October 1976.
Yes.
So now the as per in provision of the section 6, subsection 1 of the my lord, the State Act, I have submitted my lord the statements before the competent authority.
You submitted or your predecessor?
My father.
Yes.
Petition-
Paramananda.
Yes, ma'am. So now, according to my lord, the section 4.1, I can retain my lord only 500 square meter lands. The excess lands, that is the surplus lands. After going to the authority concern, if it is found the land is vacant, then a proceeding can be initiated against the land retainer. So now it appears from the my lord submitted that produced before your lordships, if it is vacant land under section 2Q1. So vacant land means, my lords, if it is the agricultural land, kindly come to section 2Q of the Urban Land Ceiling Act. Kindly see. Vacant, my lord, definition of the
Yes.
vacant means land not being land mainly used for the purpose of agriculture and urban
In an urban agglomeration.
but agglomeration does not include land on which the construction of a building is not permissible under the building regulation in force in area in which such land is situated, and in an area where are the building regulation and land occupied by any building which has been constructed before or is being constructed on the appointed day, the approval of the appropriate authority and the land appertaining to the such building. And in area where there are no building regulation, the land occupied by the building which has been constructed before or is being constructed on the appointed date and the land appertaining to the such building. So my submission before your lordships, if there, my lord, kindly consider the building. But it appears from the, my lord, the order which has been considered under section 6.1 of the my statement, it appears that I have not followed the building regulation under the Corporation Act. That is not building, that is the temporary structure. Whether this the temporary structure after coming into force of this act, whether the necessary permission is required from the corporation or not, that has not been considered by the competent authority. So now this temporary structure, no permission is required after this before coming into force of this act.
Where is it written?
Maladisa, kindly see the imprint order. They have not considered there is the provision is the building, but they have considered there is the tin set with temporary structure. That cannot be said that is the vacant land. So if the land is vacant or agriculture, then the proceeding can be, that is that the authority can proceed. That is the surplus land. They can proceed. This is, I cannot retain more than 500 square meter. That point has not been considered by the competent authority. If it is vacant, then the authority concerned can proceed. Now I have not followed the building, the regulation as per the provision of the West Bengal, the Calcutta Corporation Act. Before construction, a permission is required. So now whether this the temporary structure after coming into force or before coming into force of this act, whether the temporary structure a permission is required or not, that point, that submission has not been considered by the competent authority. While taking into
What
consideration,
is your case?
my case is this land is not the vacant land.
Why not?
Because of that, this is the a temporary, where is the
When you constructed the temporary structure?
temporary before came into force of this act 1966. I have the documents, I have otherwise I cannot approach before the civil court, before this the passing the final order. I evicted the person who were possession on that particular plot in question. Second submission before your lordships, even then, my lords, that is, whether the land is vacant or there is the structure, a physical inspection is required.
No.
How they have come to the conclusion?
If there is a structure,
Lordship,
if I take your submission,
lordship,
if there is a structure,
temporary,
whatever may be.
lordship,
So definition says vacant land means not being land mainly used for the purpose of agriculture, comma.
lordship,
So it is not required that it would be agricultural land
lordship,
in an urban agglomeration. Okay. So in the urban area, if you have any land not being you are using the agriculture purpose of that, whatever may be. If there is a land, it can be said as a vacant land,
lordship,
but does not include
lordship,
land on which construction of a building does not permissible under the building regulation in force in the area in which such land is situated.
lordship.
So if you construct anything over the land where permission is required, but you have not taken any permission to that effect, that would be tantamount to a vacant.
Tantamount means agriculture means lowland, that means the land.
Forget about the agricultural
No,
land.
now the temporary structure cannot be said to be a vacant land because a building there is.
Any structure thereon without any permission, it would be considered to be vacant land.
So no, then before came into force of this act,
Yes.
if there is the structure, but the law is very silent, my lords, that part is silent. Nothing has been, my lord, included that the temporary structure to be considered as a, if the temporary structure constructed without permission
Yes.
become a, the vacant land. Law is very clear. Building, they have only considered the building regulation. That means a permanent building with roof. Law is very clear. Nothing has been included. The temporary structure. Dwelling. On that dwelling, on that dwelling. ওটা আমরা সেকশনটা দেখে নিই ডুয়েলিং হ্যাঁ relation to a building or a portion of building means a unit of accommodation in such building or portion used solely purpose of residence.
Yes, proceed.
Now, my lord, is kindly come to Section 2E.
Section 2E.
Dwelling unit. dwelling unit means in relation to a building or a portion a building means a unit of accommodation in such a building or a portion mala kindly note it portion used solely for the purpose of residence. Mala got it?
Yes.
Now this the portion means mala it may be mala the permanent or mala the permanent with the building constructed in violation of the Calcutta Corporation Act.
What is the dwelling unit means?
Units. Mala unit
Dwelling
may be
unit.
temporary or permanent.
Dwelling unit, definition of dwelling unit.
Dwelling unit.
Whether you are you are using the building or a portion or a room thereof,
There. So now
or
in
solely for the purpose of
Of residential.
residence.
residential.
That would be the dwelling unit.
Lordship. Now
That is the definition.
2Q Malada, your lordship has considered that this temporary structure law is very silent. Nothing has been dealt with in stated in 2Q. Now, second submission before your lordship. Now the authority has come to conclusion the vacant land. How? But it appears there, Malada, the impugned order.
You have challenged that order.
Yes, appellate
before the-
authority order.
before this court.
Yes, there is no other option because of the appellate authority.
What is the decision of this court?
My reason is this: the land is not the vacant land.
No, what is the decision of this court? Appeal?
Appeal, my lord, my reason, my lord, if the impugned appellate order is goes, the subsequent.
What is the result of your writ?
My lord, nature, my lord, is the order which has been passed without considering the my lord, this.
What is the result of the writ? Whether you have preferred any writ against the order of appellate authority?
This is the writ petition.
Okay, this writ you have preferred.
Huh? Mala initially,
This is the writ.
this is the
Okay.
Malala first read my father prepared a writ petition challenging the order of the
I
appellate
have
authority.
I have heard that.
Simplify things.
I have heard that. So this writ is
Second writ
against the
petition,
order.
second writ petition challenging
order.
the impugned the appellate authority order. So second writ petition, since the first writ petition which has been dismissed without my lord deciding on merit, so my lord, there is no bar to decide, my lord, file a fresh application, fresh writ petition challenging the impugned order by a my lord, the legal heirs of the writ petition.
The order was passed in the year 88.
Hey,
Now
now
you
the
have preferred the 24.
no 2015 my father filed their writ petition challenging that there was a direction. My lord, this my father Prabhanananda, my lord, I have stated in my petition that this writ petition is the second writ petition challenging the same self order.
So where is the earlier order of the writ petition?
My lord, this the earlier my lord, the writ petition dismissed for default.
Dismissed for default.
Dismissed for default
Where is
without
the order?
my lord, this the order, my lord, this is the writ petition dismissed for default 2003 of writ petition which was filed my father in 2015, the same as my lord, item number 11.
Item number 11.
11, my lord, this the cause of action.
No.
My lord, may I submit? My lord, the challenging the order of the appellate authority, my lord, Pranamanan board, my lord, filed a writ application before the honorable court. The order dated, my lord, 11th of, my lord, 16th of November, 1988.
Yes.
That order was challenged before the honorable court.
Mhm.
That, my lord, writ application was dismissed for default. Order passed by Honorable Justice in
March.
2003. That was dismissed for default. Thereafter, my lord, he has come, legal heirs has come and filed this writ application. Since that was hard on merit, he has filed.
Paragraph 26, I have stated, but details has been given, father, which has been filed in my lord 99.
Without setting aside the order of dismissal, how can you file a
My lord, the second writ petition is no bar, my lord, lordship knows, my lord, if the matter is not hard, setting aside of my lord, this the earlier order, then my lord, the question of substitution, then my lord, the recalling of this order.
whatever may be the question?
So now the writ court will not, my lord, the proceed on the basis of the second writ petition, that is the settled law by this Honorable Supreme Court. If the writ petition is not heard on merit, in my lord, this I have shown this judgment before the Honorable Justice Pattanayok 1979 3 SCC 135. If the writ petition is not heard on merit, second writ petition is no bar on the self cause option by the legal heirs or other interested parties. So here in the case is this, my father filed the writ petition in 99, challenging the impugned order which has been passed by the appellate authority. That writ petition was dismissed for default in 2003. So now subsequent they issued the notice in 2013. Then I have come to know that this my father filed this writ petition. Then writ petition was heard without hearing, without on decide on merit, dismissed for default.
So without setting aside the order of dismissal.
So
you
my lord,
filed
there
the-
is no my lord, this kindly consider one judgment of this.
Whatever may be.
My lord, this that's restoration.
Where is the ground for limitation? There
My
is
lord,
no
the
ground
limit-
for limitation. One after another, after 50
No,
years,
that is
one
not-
shall come
no.
and say that my father was there.
It's true, my lord, it's
Then-
true. But I have no knowledge because then my lord, this the appellate authority's order. That order is not decided or decided on merit by any authority or any court of law. So now the question of third party interest does not arise because of that there is no third party. They all are the state. It is the settled law this that if the third party interest is not involved. So now the lordships has the power to exercise under Article 226 of the Constitution of India to condone the delay if it is within my knowledge. Then the lordship question of limitation arises.
Where you have said that you have not come to knowledge about the
So
trial.
my lord, this kindly come to paragraph 26 I have stated.
What you said?
So my lord, the several Paka dwelling structure constructed on the land in premises number such and such long before the appointed day and the said structure have been using a dwelling.
Where from you gathered this knowledge?
My lord, this the
1976 matter.
no, the order passed in 1988.
You are saying that before the appointed date, there are several structures like that.
Yes,
What your age now?
present, my lord, this the I have this is to my knowledge that has been.
Yes, this is how it is to your
My
knowledge.
lord, today is my age at about 66.
When you have knowledge about the structures before 1976, why you not proceeded before this court on the time?
My lord, my
Only
father
after
proceeded
dismissal.
because of that this property I have come on inheritance on the basis of inheritance, my lords. So now
So where is the clause for condonation of delay? Have you stated anything?
Hmm?
Nothing has been stated there. No pleadings.
my
are
lord,
there.
26 kindly come. The
Yes.
petitioner had no knowledge regarding all the proceeding, including filing of the WP number such and such.
Yes.
My lord, got it, my lord, page 16. And my lord, this petition and order passed therein. The petitioner very recently came to learn the said facts. The respondent number 2, the appellant has not considered the case of the petitioner after taking consideration of evidence on record, and the said petition such and such has not been decided on merits. As such, order passed by the appellate order, the respondent is perverse and in violation of the 2Q that has been placed before your lordship, and the order of the appellate is liable to be settled. So now, if your lordship consider that is the the ground of that, though this I have stated that I have no knowledge. Matter was not heard on merit or to adjudicate by your lordship or by this honorable court the order of the appellate authorities. So now there is no this the third party interest is involved in this after passing this order. So now
When you came to know about the fact, when you came to know about the order of the
Malad, I have come to know that my father has challenged the impugned order of the appellate authority just after Malad,
When you came to know, where is the pleading? When you
Malad,
come to know
paragraph
first time,
20.
nothing is there.
Malad, this in this Malad this is a hyper technicality. Malad, this is
Technical
Malad, this is a delay ground. Only on the ground of
the delay. I want to know when you, being the petitioner, has know about your right
right after
I want to know.
after death of my father.
So whether you stated that,
Malad, this is the my father.
whether your father stated at deathbed that there was an order of this court dismissed for default.
In 2003.
Yes, you have to say something.
Malad, this is the
Nothing is there. How
Malad,
can I construe?
Malad, the absolute correct. Malad, this is nothing is there. Is the
Nothing is
but
there.
but
Not a single
only
line.
Malad, the fact is I have stated in this. I have no
You
knowledge.
have challenged an order of 1988 by a competent authority, and also you are not followed the order of dismissal by this court passed in WP 1504 of 1999. You have stated nothing about that. Now
Malad,
you directly come to this court.
Malad, this I have the knowledge that my father has filed a writ
No,
petition.
in a writ, you must be clear. Open your hand that I have nothing. I just come to know
After expired on my father.
yesterday. So where you have stated?
Malad,
After
only I have stated that after.
Why you have stated that this matter of WP 1504/99 order of 99, you have also not stated the date of the order also. How you came to know about the order here? Whether you have annexed that order? No.
No, Malad, that
Then-
because of that I have the knowledge when the item number 11.
So the petitioner must have stated like that.
Malad, Malad, only
From-
Malad,
from
it is
my
true.
well
It is,
wisher, I have came to know about the fact in the month of such and such, and I search the court. Thereafter, I find this is the position.
Malad, this the kindly come to once again, Malad, paragraph 18. Because
180.
18. Malad, in item number 11, my father's were Malad the added respondent number 7. So when Malad this the matter mentioned before this honorable court, he served a notice to the Malad the private respondent. So I received the notice on behalf of my father when my father has already been expired. Then after the knowledge that my father filed a writ petition in 2099. Paragraph 22. Knowledge पूरा यार जाकर भी धारा
Okay, proceed.
Now, my lord, is my learned senior page has already been my lord placed. In my lord, the writ petition, kindly come to page 93. Once again, my lord, I want to draw your lordship kind attention. My lord, this is the 93.
Yes.
So, my lord, this the after my lord, this the passing the order or clarification order of this honorable court. This appeal was taken up for final hearing, and the appellate authority has come to conclusion that notification which has been issued in 1983 on 30th of March, that notification is set aside. My lord, this is page 93, the penalty base. So now this I cannot, I once again I cannot be reiterate the submission which has already been made by my learned senior prince. If the the authority concerned, this is the second part. So far that is the second part is concerned. So now the authority concerned has not followed the mandatory provisions in terms of the order of the appellate authority. So now, if the notification, gazette notification which has been, which was published and gazetted in Calcutta, the gazette, in 1983, that notification is set aside by the appellate authority. then in terms of section 10(1), a further notification is required to be, my lord, published, as well as, my lord, this notification in Calcutta Gazette notification. So now it appears from their affidavit file in connection with, my lord, the first writ petition is concerned. Nothing has been stated that notification in 1989 has been published in Calcutta Gazette notification. That is the date is valid. If they have, so they can show that their notification is, if their notification issued in a Malada Calcutta Gazette notification, that further opportunity, that is the final statement, I have right to object. That objection to be considered and given an opportunity, further opportunity of hearing. That opportunity has not been given. That is in violation of the section Malada 10(1) and 10(3) of the Malada Urban Land Ceiling Regulation 1976.
Yes.
Now, without Malada Gazette notification and without giving further opportunity to Malada object the Malada final statement, assuming that the land is vacant land, they have the right to Malada declare the best the excess or surplus land. So now I have the right to give an opportunity to file an objection, then further opportunity after passing the order of the appellate authority. And now this, so far the, my lord, very vital point is this, so far the physical possession is concerned, section 10(5). If I will fail to comply with the notice under section 10(5) of the Urban Land Ceiling Act, then, my lord, it is under obligation, it's a mandatory provision, the authority concerned
May use force to vacate you.
Where is that notice? Where is the possession has been taken by putting my signature or signature of the person who were legally or illegally or in possession? Like, my lord, this is the first writ petitioner is concerned. So now, as on the day the first writ petitioner is concerned, is in possession on the basis of the purchase deed.
Yes.
And lordship has already been, this my context of my the submission before your lordship, that 2Q of the Urban Land Ceiling, the temporary and the building, that has not been the clearly that vacant, come with the zone of consideration of the vacant land. Second submission before your lordships, I have not given an opportunity, further opportunity or given an objection after passing the order of the appellate authority. When the notification under section 10 set aside, Gazette notification set aside, further Gazette notification is required to be issued by the competent authority by following section 10(1).
No. Your submission would be
Both.
one, not two.
That should,
If you challenge the appellate order of appellate authority, you must have challenged that. If you follow support the authority, then you can submit that 10(1).
subsequent the procedural part, mandatory procedural part, that
But you challenge whether you challenge the order
order
or
of the
support
appellate
order,
authority is bad.
then you just argue on that point. Not
Now the
other
second point, my lord. Yes. So now this is my
So have you read the order of the appellate authority?
lordship. Kindly come to page 93.
Yes, I have read it.
So far the vacant land is concerned,
Yes,
that
sir.
part it's not been considered.
21 Chetla Central Road. That is your position. So there is a clear finding.
That is a vacant land. Vacant land. Now, lordship, vacant land 2Q, whether it is has not been considered by the competent authority or the appellate authority. Though they have taken into consideration that the land with the tin set and temporary structure is there. If there is the tin set dwelling house or temporary structure exists, then the question of vacant land does not arise under the under section 2Q of the Urban Land Ceiling Act. The page 50, which has already been placed my learned senior friends. Regarding vacant land or there is any set, I have come with this only that point. Page 50,
Page
50.
of your read petition.
Yes, sir. Malad is the
Yes, order of the competent authority.
well, competent authority has come 21 Chetla Central Road land at this premises is owned by the Pramananda Bose in 16 annas share in his statement under section 6(1) of the Pramananda Bose included. This premises land with structure. Malad the land with structure in the site plan attached with the statements as many as 7 RT set were shown. See, those wanted to lease out this land and the under section act and in this dub list they furnished with the application. It was stated in the scheduled property that there is only one tile shed on the land supported by the site plan. So now a local inquiry was held. It was found that a temporary structure measuring of 10 square meter was only exist. Now how this point, there is the maybe Mala, this is the temporary structure, maybe that point in taking if the taking note of this consideration that there is the temporary structure. Now we cannot come with the definition of the under section 2Q, that is the vacant land.
You read later on. You read later sentence.
No, no. The structure was constructed without approval of the Calcutta Corporation. So my submission before your lordship is the temporary structure is constructed before coming to force in this act. No permission is required. They have not rely any provisions. Even they came into force of the Calcutta Corporation Act 1980. If any structure is there without sanction plan or without permission, that is in violation of the statutory provision. Nothing has been dealt with in the
Read later on. What is
so
their
now
finding?
it was ignored. The application for the transfer was referred on the ground tenant. It was also excess vacant land of the transferor. There is a lot of difference between the claim in section 6(1) statement and the site plans attached therewith and in the application under section 27(2) affidavit. List deed and the site plan furnished with the application. It is time hearing of objection. A different points. One new land has been made out on new. It is claimed that this piece of land, no dispute that this is the vacant land.
Yes.
So how they have come to the conclusion that is the
There is no dispute.
no.
There is no dispute by you or your father. That
My
it was a
father
vacant land.
disputed and the attached with
No,
the
no, no.
section 6(1) application site plan temporary structure shown in temporary structure. That is that they have considered section.
What you have read.
Malad is the section 6(1). My statement which has been filed before the authority concerned, it is under obligation to consider my statement may be wrong on affidavit. Site plan temporary structure 10 square meter. Malad the temporary structure is there. So then it is finding I may be wrong. I may be given a false malad evidence.
No. That is not the what. Why you are arguing otherwise? Your father said it is a vacant land. Though there is a temporary structure at the time of inspection, it is revealed by the authority.
Yes.
But your father has made an application for transfer that is showing that it is a vacant land. There is no dispute that it is a vacant land.
So
The authority considered that the structure without permission is a vacant land, and your father, being an applicant, has said it is a vacant land. So there is no such dispute in the vacant land.
malad the dispute.
Now you are raising such question. And the appeal, it was also not a point. Appeal is there on the above the area.
Yes. So the malad is the there is the
Now you are raising a point of vacant land.
so now it is again malad I am saying that the raising of voice because of the disease whether now I may be malad my father stated that this according to malad the affidavit which has been furnished by my father.
Yes.
So
your
now it is
father furnished a affidavit showing a structure.
on
And he said, though there is a structure, it may be considered as a vacant land.
No,
Authority-
since they have
authority-
considered, since the structure is without my lord taking the
author-
permission.
No, you just read it, what you have read.
No, it was ignored. Kindly
Was
come,
ignored.
sir.
Yes, because the applicant, that your father also said it is, yes, it is a vacant land, you can consider it is a vacant land.
There, since I have not, my father has not taken any permission from the competent authority. Apart from this, my father furnished the the attached the site plan and other relevant document in support. Since they, the fact-finding authority has come to consideration that since your structure without taking permission from the corporation, now you have to say that the land is become a vacant land. So now it is under obligation. What is the physical feature will come after inquiry. Physical feature will come. Whether there is, I may be wrong, I may be said this is the vacant land. Kindly come.
You read it properly, page
At
51.
the time of
It
hearing
is
of
claimed
objection.
that the piece of land not dispute, that is the vacant land,
Yes.
is the land appertains to premises number 19, not 21.
Lordship 21. I am concerned about this writ petition arising agreed with regard to the my lord declaring the vesting of excess or surplus land with regard to premises number 21.
Yes.
I am not concerned now, my lord, this the kindly that 21. I am concerned about the 21.
Yes, 21.
21. So now this the
We were
21.
saying about the vacant land or the structure thereon,
There are.
it was no objection regarding the fact that if the structure, anything is there,
Yes.
it is appertain to 19, not 21.
No, my lord, this is kindly 1 second, my lord, I am traveling.
You
to-
read it.
So now this is again once I am coming, my lords. 21 Chedla Central Road, I am talking page 50. Premises is owned by the Prabhananda Bose in Solo 16 Anna shares in this statement. In these statements under section 6(1) of the Prabhananda Bose included. These premises are land with structure. That
Yes.
is in the land
Read it.
with structure of premises number 21.
Yes.
Structure in the site plan attached with the statement as many as 7 artisans regarding 21.
7 artisan, not that structure you are saying about.
Structure is there, 7 my lord, I have furnished a false evidence or whatever it may be. What is the under
You
obligation?
just read it. You just read it. What is the finding and what your father saying?
My father said in later on, because of that, that structure has been constructed or my lord, made up by my father without obtaining necessary permission from the corporation. That is my lord, unauthorized. It may be called as an unauthorized structure, but the authority concerned cannot come with the conclusion the land is vacant land.
Okay.
So my lord, this. So now the second part is concerned. So notification or the provision or after passing the order of the my learned senior pen has already been my lord submitted. This is my only দাদা বাবু বন্দ্যোপাধ্যায় সাহেব আমি পারবো না এবার চলে যাই Good. Okay. This is my
Thank you.
good.
But I'll very soon make him uncomfortable so that he can take over.
Yes, proceed.
Lord,
You are
I appear, Lord, for the respondent state.
okay.
Now, Lord, as your Lordship has seen, the premises concerned is 21 Chetla Central Road. The owner was Paramanando Bose. Now, Lord, after the act came into force, he filed a return under section 6, subsection 1. Now, Lord, if your Lordship kindly, Lord, have a look at the act once. Kindly, Lord, see the section. It says, every person holding vacant land in excess of the ceiling limit at the commencement of this act shall, within such period as may be prescribed, file a statement before the competent authority having jurisdiction specifying the location, extent, value, and such other particulars as may be prescribed. Now, Lord, this return was necessary to be filed by a person who is holding land, vacant land in excess of the ceiling limit. Because, Lord, the section itself says every person holding vacant land in excess of the ceiling limit at the commencement of this act shall, within such period as may be prescribed, file a statement. Now, Lord, this option was exercised by the gentleman Paramanando Bose. Now, Lord, after section 6, your Lordships may kindly have a look at section 7. Lord, 7 is not important. Please come to 8. Now, Lord, once the return is filed, it becomes incumbent for the statutory authority to prepare, Lord, a draft statement as regards the vacant land held in excess of the ceiling limit. Based on the report, return
submitted by the.
So, Lord, power under section 8 is exercised. Now, Lord, it says on the basis of the statement filed under section 6 and after such inquiry as competent authority may deem fit to make it, the competent authority shall prepare a draft statement in respect of the person who has filed the statement under section 6. Then every statement prepared under subsection 1 shall contain the following particulars. Then please come to 3. The draft statement shall be served in such manner as may be prescribed on the person concerned together with a notice. Then 4. The competent authority shall duly consider any objection received within the prescribed period specified in the notice. So, Lord, 8 contemplates that once a draft notice is given, an objection is invited. That if you have any objection, you file your objection at the section 8 stage.
Yes.
Now, Lord, if your Lordships kindly comes to page 40, 41.
40.
40.
First read petition.
Lord, I am.
Yes. First read petition. 40.
Yes. Lord, this is Lord 2015 writ petition.
Yes.
Kindly, Lord, come to page 40. Kindly see at the top, it says order on hearing of objections. Has your Lordship found that? Under section 8.4 of the Urban Land Ceiling Act, in connection with case number 6.1 in the name of Paramanando Bose, in the name of Santosh Kumar Bose and in the name of Sudhir Kumar Bose.
Yes.
But there were three brothers who had adjacent property, owners of adjacent property. They had all filed return under section 6 and they were given notice and they were heard together. Now, my lord, please come to paragraph 46.
There is a 12:30 fixed matter.
Not possible today. Next Thursday it will happen. Just wait. Next Thursday তে কিছু আছে 12:30 তে দেখুন 12:30 তে আছে কিনা দেখুন নেক্সট থার্সডে 12:30 আছে কিছু নাম্বার 2
Item number 2.
এটা করে দিন ইয়েস
Now, my lord, can I please come to page 46. 46, round the middle, Lord, 21 Chetla Central Road, has
Yes,
got you got that?
ইয়েস
Land at this premises is owned by Paramananda Bose in 16 Anna's share. In his statement under section 6.1, Paramananda Bose included this premises as land with structure. In the site plan attached with the statement, as many as 7 RT shades were shown. Sri Bose wanted to lease out this land and applied under section 27 of the Act. Lord, this is prior to Lord filing of the statement under section 6. Prior to adjudication of the statement under section 6, he had made an application under section 27 seeking leave to let out this property. Lord, a grant lease. Under section 27, this is permissible. I mean,
Okay.
you have to obtain the consent of
permission
the-
from the department and to lease out the property
Yes. Now, my lord, it says in the draft lease deed furnished with the application, it was stated in the schedule of the property that there is only one tile shade on the land supported by the site plan. A local inquiry was held. It was found that a temporary structure measuring 10 square meter only was existing. The structure was constructed without the approval of the Calcutta Corporation. It was ignored. The application for transfer was referred on the ground that it was the excess vacant land of the refused, it should be, on the ground that it was excess vacant land of the transferor. There is a lot of difference between the claim in section 6.1 statement and the site plan attached thereto and in the application under section 27.2. The authority finds that there are incongruities. Affidavit, draft lease deed, and the site plan furnished with the application. At the time of hearing of objections, a different point on a new land has been made out. It is claimed that this piece of land, no dispute that it is a vacant land, is the land appertaining to premises number 19 Chetla Central Road. So his brother's land was adjacent, that had structure. So claim was raised that this is
not my plot this
this-
is 19
a part of, yes, it is part of 19. That was what was claimed. 19 Chetla Central Road, appertaining to premises number 19, which is stood to be having as many as 5 dwelling units. It has already been discussed in connection with objection in respect of premises number 14 Pyari Mohan Rai Road, that land appertaining to a building cannot spill over to another premises, and the same logic applies here also. Moreover, there are some other facts which are relevant here. Premises number 19 Chetla Central Road belongs exclusively to Sri Santosh Kumar Bose, as we got from the 6.1 statement and site plan attached thereto of Sri Santosh Bose, whereas premises number 21 Chetla Central Road belongs exclusively to Sri Paramananda Bose, as mentioned in his statement under section 6.1. Neither Santosh Bose did anywhere in his statement mention that he had any claim whatsoever on 21 Chetla Central Road, nor did Paramananda Bose give any indication in his statement he had interest in 19 Chetla Central Road. it is now clear that their two premises belong to two separate persons. Naturally, land appertainant of a building owned by one person cannot be at a premises owned by a different person. How the copy of assessment book of Calcutta Corporation, now it should be, the copy of the assessment book of Calcutta Corporation can show Paramananda Bose as the owner of premises number 19 appears to be strange. In the affidavit filed by Paramananda Bose in connection with the application under section 27, it was not stated that he was holding premises number 19 also. Again, Santosh Bose in his statement mentioned that structure at premises number 19 is a non-residential one. The copy of the assessment book showing a transport agency is the occupier, collectorate corroborates this. The huts has therefore been constructed later on. Hence, land at premises number 19 should also be treated as vacant land. Therefore, the objection with regard to 21 Chetla Central Road fails. It has been correctly assessed as the vacant land. Now, my lord, then it goes on to the other properties. We are not concerned. Now, my lord, this finding, this was a adjudication under section 8. Now, Lord, against this, Lord, they preferred an appeal. That appeal got dismissed because, Lord, of non-prosecution. But subsequently, they filed a writ petition. And in the writ, the High Court directed us to go back to the appeal stage, dispose of the appeal on merits. So, Lord, not touching the order under 8, but it says that you go back to the appeal and start from appeal. Now, Lord, the appeal was disposed of. Kindly, Lord, take the order of the appellate authority, final order. There was an earlier order, then, Lord, that got superseded. Kindly give me 1 minute. Final order. 16 November 1988. Yes, Lord, kindly come to the rejoinder affidavit. Kindly come to rejoinder affidavit, paragraph 11, it starts.
Yes.
Page 11, sorry. Lord, I did not need not trouble your lordships, Lord. Kindly come to page 22 straight away. Paragraph 4.
Yes.
I accordingly find that though all the contentions in the appeal petition and oral argument cannot be accepted in toto, the competent authority Calcutta has not acted in accordance with law in determining 2524.60 square meters of land at premises number 1, so and so. Kindly come to 21 Chetla Central Road, so and so, to be excess of the ceiling limit of the appellant and hence liable to be surrendered by the appellant. He owned so many premises. Therefore, Lord, there was a direction to re-adjudicate. Kindly, Lord, come to this. In the result, the appeal succeeds. The final statement issued under memo number such and such. Final statement is under section 9. 1980 is set aside. The notification under section 10(1), 10(3) of the Act published in Calcutta Gazette Extraordinary are also set aside in the circumstance. It is ordered that the appeal is allowed on consideration of merit. The competent authority Calcutta is directed to prepare final statement on the basis of 651 square meters of excess land at premises number so and so, 233 square meters of excess land at premises number such and such, 802 excess land at premises number 21 Chetla Central Road. Has your lordship found that? So, my lord, the appellate authority determines what should be the extra vacant land. Now, my lord, based on this, Lord, at section 9, a fresh notice under section 9 is issued. Now, Lord, your lordships kindly come to section 9 once.
Yes.
After disposal of the objections, if any, received under subsection 4 of section 8, the competent authority shall make the necessary alterations in the draft statement in accordance with the orders passed on the objections aforesaid, and shall determine the vacant land held by the person concerned in excess of the ceiling limit, and cause a copy of the draft statement so to be altered to be served on the manner referred to in subsection 3, etc. So, my lord, notice under 9 served. No determination was necessary because the appellate authority had prescribed that what should be the extra vacant land. Now, my lord, one point I just want to point out that, my lord, the owner at that time did not challenge the order of the appellate authority. He did not. On the contrary, once the notice under section 9 is served, he challenged the notice under section 9 by filing a writ petition, which got dismissed. Your lordships may kindly take the second writ petition and come to paragraph 18.
Yes.
Kindly see paragraph 18. It says that Paramananda Bose filed an application under Article 226 of the Constitution of India for quashing the impugned order and for preparation of statement under section 9 of the said act and for restraining the respondent authority from passing order of wasting on the basis of final statement. The said writ application so and so of 1999 appeared before the Honorable Girish Chandra Gupta on such and his lordship was pleased to dismiss the said writ application. Now, my lord, insofar as the section 9 is concerned, the final statement was issued, my lord, on 22nd May 1989. And, my lord, this challenge failed. Now, my lord, 23rd June 2010 is the date when, my lord, Paramananda Bose dies. And, my lord, his son Vivek Bose, who's now, my lord, filed this application in 2024, Lord, he challenges, Lord, the order of the appellate authority. In fact, the order of the appellate authority, your lordship has seen,
In the year 1988, November 98.
98. 80. So, my lord, countless years have gone by, and whether your lordship will entertain the second writ petition is doubtful. Now, my lord, interestingly, there is a transfer. Therefore, by dint of transfer, in 2015, this Fighters Lodging Syndicate, they have filed the writ petition. Yes. Now, my lord, this transfer takes place on 18th of December 2003. কোথায় আছে বলে দাও এই অ্যাভারমেন্টটা কোথায় আছে বলে দাও 18th of December. Yes. Correct. This is not, please take not paragraph page 21, paragraph 28. Page 21, paragraph 28. Apparently, my lord, it appears that there was a friendly suit for specific performance, and lord, in which a decree was obtained, and lord, this conveyance was executed. But my lord, perhaps while executing the conveyance, lord, your lordship is looking at the second writ petition. I am referring to the first one. Therefore, for the second writ petition, I just wanted to show, my lord, the one paragraph that there's the second writ petition.
In the first writ petition,
First writ petition, page 21, para 28.
okay.
It says that a deed of conveyance was executed by Paramananda Bose in favor of the petitioner number 1. Now, my lord, when this conveyance was executed, perhaps, my lord, section 5, subsection 3 was lost sight of. This is deed is a nullity. Your lordships may kindly take section 5, subsection 3. Section 5, subsection 3.
Yes,
In any state to which this act applies, in the first instance, and in any state which adopts this act under clause 1 of Article 252 of the Constitution, no person holding vacant land in excess of the ceiling limit immediately before the commencement of this act shall transfer any such land or part thereof by way of sale, mortgage, etc. So not only restriction is to the entire land, but also part thereof.
yes,
And Lord, here the owner had admitted by filing the statement that he was holding land in excess of the ceiling limit, which was adjudicated to be in excess. So, my Lord, question of any transfer does not arise at all. So, my Lord, this writ petition, which has been filed by this logistics, is also, my Lord, not maintainable, because he has obtained, my Lord, he is a post-vesting purchaser.
yes.
Now, I just, Lord, take 5 minutes to conclude. Lord, we are at the stage when section 8 is complete, section 9, Lord, challenge is gone. Only thing that remains is the action under section 10. If your lordships kindly take, Lord, section 10. Your lordships will find it says, as soon as may be after the service of the statement under section 9 on the person concerned, the competent authority shall cause a notification giving particulars of the vacant land held by such person in excess of the ceiling limit and stating that, etc. Then, Lord, kindly come to 2. After considering the claim of the persons interested in the vacant land made to the competent authority in pursuance of the notification, the competent authority shall determine the nature and extent of such claim passed by such order as it may deem fit. Now, Lord, I concede that 10.1 notification was published, but it was not, Lord, Gazette notification. So, Lord, we have to go back to that 10.1 stage and, Lord, publish a Gazette notification upon which he again gets a chance to file an objection. And your lordships will find 10.3, 10.2, the authority has to consider the claim of the petitioners. And then 10.3, at any time after publication notification under subsequent competent authority may by notification published in official gazette concerned declare that excess vacant land referred to in the notification under section 1 shall be with effect from such date, etc. So, my Lord, there has to be a further adjudication in terms of section 10. There has to be a gazette notification under 10.1 followed by an objection, entertainment of the objection, disposal of the objection, and then, Lord, final publication 10.3 and ultimately 10.5. Your lordships will find that final publication has to be made. So, my Lord, this adjudication process is still outstanding. From 2015, Lord, we are stuck on this litigation. So, I would request your lordships to kindly, Lord, dispose of both the writ petition. Lord, holding that, Lord, the purchaser has no right, but Lord, owner's son,
Yes,
who has inherited the property, he will have a right to, Lord, object, and we will give him a hearing, and Lord, we will pass an appropriate order following section 10. From 10.1 stage, we will start the proceeding. Agenda কোন paragraph? 9. ঠিক আছে, এটি এমনি আগে 10.5 টা was addressed to fighter logistics. আরে ফ্রেশ নোটিস একটা ইস্যু করে দাও না ভাই, কি আছে?
yes,
Lord, therefore, Lord, these are my submissions. Lord, if any notice has been issued to the fighter logistics, Lord, that was issued, Lord, in ignorance of the provisions contained in section 5, subsection 3. Therefore, Lord, we can only, Lord, see the original owner and, Lord, his heirs, whoever it is. So, Lord, kindly, Lord, give us liberty to proceed with the matter from section 10.1 stage.
My lord, your lordship, kindly give me some 5 minutes time, so I shall give reply to this. That I have no, my lord, so far the my lord, I have no legal right to file the writ application on this point. I shall make submission. After 2, I shall come.
দুটোর সময় আছে, সময় অরিজিনাল সাইড আছে, হ্যাঁ, আর একটু টানবো আমি তাহলে। Come on to
Yes.
containing. Yes.
My learned friend has submitted. So for other points, I am not dealing with because he has accepted my lord, my lord, what I have stated. So far, my lord, my right to file the writ application on this point, I am making submission. My lord, your lordship, kindly come to my writ application. I have stated before your lordship that initially the petitioner number 1 was a tenant, was inducted as a tenant in respect of the premises, 21 Calcutta Central Road. That I have stated, my lord, in my writ petition. Paragraph, my lord, 15, page 14. The petitioner was inducted as a tenant in respect of the premises.
Paragraph?
Paragraph 15, page 14.
Yes.
That on 16th of April 1982, the petitioner number 1 was inducted as a tenant in respect of that premises. And that, my lord, your lordship, kindly come to page 38, the corporation record that will show the name, my name will appear from the corporation record.
Yes.
That name of the occupier, Mrs. Fighter Lodging Syndicate Private Limited. Your lordship, kindly come to page 38. Column number 5. First, column number 1, the premises number 21 at the top, street name Calcutta Central Road, and column number 5 that will appear Mrs. Fighter's Lodging, that is the petition number 1. And I was inducted as a tenant in 1982 in terms of the agreement. Column number 12, there some correction was made and assessment was done. So these documents will show that initially I was a tenant. And thereafter, my lord, in terms of the decree, my lord, that was transferred, the premises was transferred in favor of the petition number 1. And even if, my lord, it is accepted that the transfer under section 5 is, my lord, illegal and void ab initio. Void ab initio, my right of tenancy will not go. And I am in still occupier. And from the notice, my lord, it will appear that I am in possession. I have some legal right over that property. That's why notice was issued in favor of me. Some interest I have. Initially, I was a tenant.
If you are tenant thereon,
Yes.
thereafter you are a transferee.
Yes.
So what are you claiming now? Is
No,
it
no, my lord.
tenant or transferee?
No, according to my lord, my learned friend, if it is a documents is void ab initio, my right will not go. Tenancy right will not go. That will not merge. That will not merge with that. My lord, your lordship, kindly come to that definition. Section 5. Induction of tenant is not a transfer. So my transfer, my tenancy will remain. And he cannot say at the same time that the void deed is void ab initio and I am not a tenant, I am an occupier. Kindly come to, in any state to which this act applies, in the first instance, where any person who held vacant land in excess of the ceiling limit at any time during the period commencing on the appointed day and ending with the commencement of this act has transferred such land or part thereof by way of sale, mortgage, gift, lease, or otherwise So these transfers should be by way of sale, mortgage. So tenancy, induction of tenancy is not a transfer. It is, my lord, from the statute itself clear. It will be further clear from the definition. Your lordship kindly come to the definition, my lord. My lord, 2L. Induction of tenant, my lord. 2L. My lord, 2L. I am holding to hold has been defined. To hold with the grammatical variations in relation to any vacant land means to own such land, owner can hold that land, and who? To possess such land as owner or as tenant. Even if tenant, my lord, holds the land, he has, my lord, right to hold that land. So induction of tenant, my lord, cannot be, my lord, bar under section 5. So I have right over that property, even, my lord, the deed is void ab initio. And that's why they have issued the notice. And even, my lord, your lordship kindly come to section 6. Statement should be filed by whom? The person who holds the land. Even a tenant has a right to, my lord, submit return. To submit statement under section 6. Your lordship kindly come to section 6. That's why, my lord, notice, if the publication is made, I have right to, my lord, raise objection, file objection before the authority.
Yes.
So under any circumstances, my lord, this notice issued by the, my lord, authority, my lord, cannot stand. Your lordship kindly set aside the notice, both the notices, and your lordship kindly
Remand the matter back
direct-
to the authority
direct the, my lord,
so that we can.
direct the, my lord, authority to, my lord, comply with the provision under subsection 1 and thereafter subsection 3, and thereafter, my lord, all the, my lord, provisions which is required to be complied with. That is the order of the, my lord, appellate authority. And your lordship kindly direct, set aside all these. And till then, my lord, your lordship kindly protect me. They cannot disturb my position.
No, this
Because
may I also
they have to-
submit a few points?
They have to issue notice under subsection 5 of section 10. Unless they comply with that, they cannot disturb my position without
Um,
due process of law.
Yes.
This is my submission.
When my learned senior friend was arguing, when I am being led by Mr. Joydeepkar, and he has argued at length in this matter, not once did we say that you please don't go before the authority. We said we will issue you appropriate notice. You come. You give your claims and objections. We will consider it in accordance with law. So this argument of my friend again, in retaliation of all the arguments that were laid before your lordship by my learned senior who was leading me in this matter, I do not know why he is so inclined to waste the time of the court.
No, I am not wasting
No,
time, my
please,
lord.
I am also wanting to draw lordship's kind attention towards this notice, which I have been handed over as an additional set of.
Hello, what notice he is submitting? My
Are you please wait, it is in your favor only.
without giving me a copy.
Are baap, please, something should be between the court and me.
Without you cannot place any.
I am
without
saying that we are ready to withdraw the notices that were served upon you.
That is the order. That is the, my lord, your lordships, my lord.
Yes,
will
that
give that order.
that is why I have placed before the court.
Why are you fighting?
I am not fighting.
Your senior argued this matter.
Yes, 100% now. If he is not there, then it is my bounden duty to place certain facts. If you would not have been there, your junior would have.
Okay.
My lord,
It
is
is a very
placed-
clear case, your lordship, where the department says, and this is a documented evidence which I am producing with seal, signature, and of the concerned department and officer, that we are ready to withdraw the notices, because we also feel that notices under 10.3 and 10.5, which were duly served upon him, were wrongly given.
So, my lord, if they are withdraw, my lord, without, my lord, filing, my lord, supplementary affidavit. And I
But
challenge that you must kindly set aside this.
This has,
They are admitting your claim.
yes.
I understand,
Then
my lord.
I am passing the order. You don't have to worry.
Apre.
Yes.
Not even the aspirant GIT, an officer of the aspirant GIT was appointed by the directing him to take position. Hereby the authority came. Because the authority had the take position and take the position. The power remains to the here. And the officer of the aspirant GIT was appointed as
Custodian.
and he was authorized to take possession. In pursuance of this authority, the custodian issued notice.
Yes.
Custodian has to act without under the direction of the it has no other power or no other because now without and basically without
Yes.
I cannot say. Here's the point taken asked by government. So the material there is there they have the concept.
Not to sell.
And we come to this petition has page 15. Now my government is taking a U-turn
Yes, exactly.
with the
Tenancy. Now it's come to tenancy.
just page 15 of the petition and paragraph 18. In what capacity he has filed the rate? That's owner.
Yes, exactly. Exactly.
And because for a moment, when we take the secondary petition, paragraph 1, paragraph I will say, paragraph 21 of that.
Yes.
21, my lord, and it for one of the books executed a sale deed in favor of the said tenant by the public. It was registered the registered of 1 transferring the land and further structure. I have that because the second petition was
Yes. 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 Yes.
the property is sold, the construction. So we are I'm here because my lord knows the second position of law. The rich code because cannot and not travel the beyond the scope of the rich. And if subsequent transfer goes, his right
It goes.
he had filed this declaration seeking declaration for pursuit of that notification as the owner, not as the tenant. He has not amended or withdrawn that petition and filed afresh the capacity of tenant. So, in the capacity of owner, when someone wants to maintain a petition, then he will be a specific bar, and he cannot, at the bar make out a
Travel
case.
beyond that.
At the bar, he cannot make out a case that he was a tenant. His tenancy goes the moment
It is infructuous.
It
It goes. That is all, your lordship.
Because both the parties, the tenant and the landlord, entered into the agreement. Transfer is not right. So now he cannot go back to that. Even if he wants to go back, he has to find a fresh. He cannot maintain this petition, otherwise that will. So whether my question would be about whether you'll be not be entitled to hearing under.
We are filing this spirit picture.
If he had sold out the property, what right he had? And the second petition also, since
He is a tenant.
during the subsistence of that tenant, the transfer will be by give no right to the equity. So both the petitions
Not maintainable.
are not maintainable in value because the cost can be double. Now at the bar he cannot make a petition. That's not
That is all, your lordship, the submissions that I have made. I have,
The bar, matter what I.
Arey, one moment, sir.
Yes, you make your submission. I am not disturbing.
No, I also never make it a point to disturb others.
Yes.
But still, so your lordship, this is the submissions. We have put our contentions, supporting it with annexures, supporting it with laws. We have not traveled beyond law, and everything that we have done, even admitting that yes, 10-3 at that point of time should not have been there. What last document that I have given before your lordship. So whatever remedy is available in the statute, I would pray before your lordship that judgment be passed accordingly.
Okay. So where is the petitioner of second writ petition?
He is only,
Second petition, I am not the petitioner.
Yes.
First petition, I am the petitioner.
Very good. Very good. Yes, yes, yes.
This letter 30 is also
no, it will be a long judgment, don't worry.
I'll pass out. Please take down. Item number 11. কেন এটা ব্রেক হয়ে যায় বুঝতে পারছো না আমি ছোট করে দেব। তাহলে কে নিল এটা নেটে থাকো 10 মিনিটে শেষ করে দেবো। বেশ আচ্ছা ঠিক আছে চলো ধরো The petitioner challenge order of vesting passed in UL case number 6 within bracket 1 stroke 91 stroke small v 4 of 1976 by the competent authority. He also challenged a notice dated June 4, 2015 passed by the competent authority, ULC, Kolkata, under section 5, under section 10, within bracket 5 of the Urban Land within bracket Ceiling and Regulation bracket Close Act 1976. Full stop. Brief fact of the case is that the brief fact of the petitioner is that he was inducted as a tenant in respect of premises number 21, Chetla Central Road, Calcutta 27, by executing an agreement between the petitioner and one Paramanando Bose on April 16, 1982. Since then, the petitioner was possessing the said premises. During such possession, the said Paramanando Bose intends to sell out the premises to the petitioner with highest mark intends to sell out the premises to the petitioner with highest market value of rupees 50,000 per kata. However, such agreement was not materialized, and subsequently a suit was filed by the petitioner, which was ended to execution of a sale deed in favor of the petitioner through additional sub-registrar Alipur. By such, the entire property was transferred in the name of the petitioner by the registered deed dated October 1st, 2003 by deed number 2908 2003. It is the contention of the petitioner that while he is in possession, suddenly the competent authority issued the impugned notice on 4th of June 2015 directing the petitioner that as he has purchased the premises after the order of vesting, after the submission of return by Paramananda Bose, the said transfer of land is unlawful under section 5 within bracket 3 of ULCR Act. Full stop. petitioner also challenge a notice dated a notice dated 19/6/2015 issued by valuation officer KIT, being the custodian of the vested land. Full stop. To understand the issue involved in the instant writ petition, the facts in a nutshell required to be demonstrated regarding the factum of vesting. No, the factum of vesting required to be demonstrated herein. To understand the issue involved herein, কি বলা? No, the facts they কেটে দিন, the facts they কেটে দিন, factum of vesting, facts they কেটে দিন, ওই যে বলেছি না factum of vesting, ওটা কি বলেছি factum of vesting, required to be demonstrated. Next paragraph. One Paramananda Bose, Santosh Kumar Bose and Sudhir Kumar Bose are the co-owner brothers of property being being 21 Chetla Central Road, (14) Parimohan Roy Road, and 12 Parimohan Roy Road. Full stop. Paramananda Bose submitted statement under section 6(1) of urban land within bracket ceiling and regulation bracket close act 1976 with the authority concerned. Full stop. The competent authority, on the basis of such statement, has prepared a final statement under under subsection 2 of section 6 of the said Act 1976 against the said statement, objections were called for, and thereby Paramananda Bose has filed objection under section 8 within bracket 4 under section 8 under section 8(3) of the said Act 1976. The competent authority, the competent authority has heard the objections under section 8(4) of the said Act 1976 and passed a detailed order. By such order, the competent authority has held that an area of 2524.60 square meter is exceed to the ceiling limit of Paramananda Bose in respect of the said premise, in respect of the said 21 Chetla Central Road premises. Full stop. Against such order, Paramananda Bose went up to this court by filing a writ petition. Finally, the writ court has directed the said Paramananda Bose to approach the appellate forum. Accordingly, the said Paramananda Bose preferred an appeal under section 33 of the Urban Land within bracket Ceiling and Regulation bracket close Act 1976. Full stop. The appellate authority has modified the order of the competent authority and has ordered that set out করবে 23 এটা মার্ক করা আছে 1 মার্ক করছি 1 মার্ক করছি এটা জাস্ট আগের পেজের এই অর্ডার থেকে হবে ঠিক আছে ওটা থেকে ওটা হয়েছে the concerned authority next para after the order of appellate authority has been passed, the respondent authority has proceeded to issue the final statement under section 9 of the said Act 1976, which was initially challenged by Paramananda Bose by filing a writ petition being number (1504) of 1999, which was dismissed for default by this court, by a corner bench of this court, by order dated September 21, 2003. Full stop. Thereafter, the respondent authority had issued the impugned memo upon the petitioner under section 10 within bracket 5 of the said Act 1976, directing the petitioner to deliver the possession of such excess land held by him immediately. Full stop. In response to such notice dated 4th of June 2015, the competent officer, the valuation officer, KIT, being the custodian of vested land, has also directed the petitioner to deliver the possession of the vacant land. Full stop. Both the notices are both the notices are impugned herein. Full stop. During the course of argument, it has been categorically and fairly argued on behalf of the respondent authority that impugn notice under section impugn notice dated 4th of June 2015 under section 10 within bracket 5 of the said act was issued upon the petitioner on misconception of law. Full stop. They actually have to proceed it under subsection 1, section 10, and thereafter subsection 3 and section 10 of the said act 1976. Thereafter, they can follow or pass the said notice. By such, they intend to withdraw the said notice. Full stop. During the course of argument, next paragraph, a memo was placed by the competent authority dated 13th of November 2024 that they with intention to withdraw the said notice being incorrect one. Full stop. Having heard the learned counsels for the parties, the impugn notice, as admitted to be improper in the eye of law, is hereby set aside. Full stop. Next paragraph. The setting aside of the impugn notice cannot dispose of the entire litigation herein. Full stop. The petitioner, the competent authority has challenged the maintainability of the writ petition filed by the petitioner, containing inter alia that the petitioner, being a purchaser of the land which is excess to the ceiling limit of returnee Paramananda Ghosh, limit of returnee RETURNEE, returnee Paramananda Ghosh, and the transfer after the date of vesting is barred under section 5 within bracket 3 of the said act 1976. Full stop. Learned counsel for the petitioner submits that fact suggests that he was in possession over the land as a tenant. Thereafter, the premises was transferred to the petitioner by dint of a registered deed of gift, registered deed of sale. Thus, he, being a person holding the land, has some legal right to demonstrate, to challenge the challenge the notice and the procedure of vesting initiated by the competent authority. Full stop. Considering the entire aspect, it appears that the petitioner has challenged the impugn notice dated 4/6/2015, which was admitted by the respondent authority to be a notice issued on the misconception of law. Thus, the instant writ petition is disposed of. Thus the notice, impugn notice dated 4/6/2015 is hereby set aside. Full stop. The petitioner, the respondent authority, is directed to initiate the proceeding according to the direction of the appellate authority, since the stage of section 10 of the Urban Land Sealing and Regulation Act 1976. Full stop. On that score, I make it clear that the issue regarding right of the petitioner to right of the petitioner in respect of his possession over the said excess land is to be determined by the authority after giving him a reasonable opportunity of being heard. Full stop. The authority concerned shall conclude the proceeding, conclude the all exercise within 8 weeks from the date of passing of this order, from the date of communication of this order. Full stop. I make it clear that this court has not entered into the merit of right of the petitioners in this writ petition. It is kept open to the competent authority to decide the issue afresh without being influenced by any observation of this court. Disposed of.
So far the second writ petition is concerned.
Yes, I am passing that order.
Malad, so now, first writ petition is concerned, your lordship has given a liberty to give Malad, opportunity of hearing. Since the second writ petition is concerned, Malad, that no observation, no order has.
No, I want to hear you. That is the issue. They have already argued. You have not heard.
Malad,
Your reply. What is your reply?
Your subsequent action which has been made by the authority concerned, that part has been set aside by your lordship. So now the rest of the part, my part is concerned, because of that I am entitled to get an opportunity, because of that I am the landowner.
That also is the first, if I am saying something,
Lordship,
correct me if I am wrong.
No, only submission was made. You have not heard it.
Yes,
Submission was made by the state authority that you have no right to file the locus standi to file the writ petition because your father has challenged the notice under section 9, and you have, that means he has admitted the order of appellate court,
Yes.
appellate authority,
Against the appellate order.
yes.
not appellate authority.
Yes.
Appellate authority order has been passed. Thereafter, competent authority issued a section 9.
No, I have.
That is the
challenged-
final notice. And
Then
you
five-
challenge that.
then five, I have no objection because my senior friend's client has the objection. So for the parent's order, which is under challenge by my father, then during the pendency
Your
of
father has not challenged the
yes, so
order.
appellate authority's order has been challenged.
Section 9 notice here.
No,
you have-
no,
No,
that is
no,
not
no,
correct.
no,
That
not
submission is
even
wrong. That submission is wrong.
wrong.
I shall show from the matter.
But this is not
No,
correct.
no. What they have submitted that.
Yes, that is
You
not
read
my-
the paragraph 11. Paragraph 11. You read
Great respect. I
section 9.
You'll also kindly come to page 12, paragraph 18.
They have
My
said why you came here so long
My lord,
after so long time.
my learned friend, my lord, petition, you'll also kindly come to page. My lord, Mr. Kaur, my lord, with great respect, my lord, what a petition says, I am placing. My lord, paragraph 18, page 12.
Yes, yes.
Paramananda will file an application under
Second, na?
Article
Yes.
under Article 226 Constitution for quashing the impugn order and for preparation
preparation.
statement, both,
Both.
not my lord statement. That is the wrong submission made.
Appeal under section 33.
It
Very
is
good.
not only mere statement, it is my lord order and also my lord
Also
statement.
statement.
After so many dates, what is your now?
That is
That
current
is
thing.
lordship. That
That
is
different
I
thing.
have.
Factually,
That has to
That-
be factual.
my lord, factually,
That is only challenge.
my lord, order has to be, my lord, your lordship has gone, this fact has gone down, your lordship's, my lord, order. But factually, it should be, my lord, it's my duty to want to point out your lordship, that not only, my lord, section 9 was challenged, it was also order was challenged. That is in the writ.
And also my pair A is also.
What?
Well, it may be
No,
joint
whatever may be. My lord, I-
This is not.
my lord,
this is
being
what-
my lord, whatever it may be, my lord, my lord,
No, you have not. You have not taken very precisely the order. Order is that the authority was given liberty
No,
to
no, what is-
proceed since section 10.
What is in the writ-
That means the final order is there.
my lord, what my lord, Nalin
Yes.
friend has stated in the writ
100%.
petition, I have, my lord, shown to your lordship, my lord, not only my lord, section 9,
Lordship,
my lord,
I understand. I understand.
my
Order-
submission
order is
before
also-
your lordship, either the writ petition which has been filed, it may be barred by limitation, lordship can dismiss it. That is lordship. Now, my submission before your lordship, my father challenged the order of appellate authority which was filed under section 33 of the my lord, the urban land ceiling regulation act. If the point of limitation lordship consider, I have no case. Because of that, the writ petition dismissed for default in 2003. My father have no knowledge. Then I have the knowledge. If your lordship kindly go through that order, if the opportunity to give an opportunity of hearing to raise all objection before the authority concerned, my learned friends have no locus standi because of that he is in possession by virtue of the subsequent deed. Correct. If the entire vesting order, appellate authority order goes, then automatically my learned procedural lapse.
Very good. Very good. Hard. Hard. I am passing the order.
So that is only my learned, because let them to
Okay.
decide.
Okay.
Here, one line may I. An admitted fact that the petition was filed by his father, that was dismissed for default.
That he's
And
saying.
dismissed for default, that
on
was
record,
never
on record.
Yes. I mean,
Under
agree.
circumstance, whether the practical is entitled to file a fresh writ petition
After so many,
to challenge the fresh the same thing.
after so
My
many.
lord, yet one judgment of this honorable court delivered by my lord the foreign court, as this lordship then was in 2000. You know, I have not brought that judgment, but I can give the citation. There, the writ petition was allowed.
Now, my lord, only one submission with due respect to my learned senior friend.
Was not permitted.
1979, I have placed this judgment, my lord Justice Pattanayak. Consider then,
If this practice is allowed, then there is no need to make
CPC
a
da-
petition for restoration.
yes, my lord, the restoration is a 90
If this is for default, another petition will come. There will be-
division bench of my lord presided over my lord Justice Sotroboto Sinha in a writ proceeding. The questions of my lord further, my lord, the substitution is not required if the writ petition is abated or because,
That is abatement,
and now here is the abatement question of
not abatement.
but my
Abatement
father,
and dismissal is separate issue.
my lord, this is the issue of 79 3 SCC 135 Supreme Court held. If the writ petition dismissed on merit,
may consider this judgment.
my lord, then I will come that judgment, both the judgment.
If this does not require such an exhaustive.
Then my lord,
hearing,
authority court.
Because first writ petition decides most of the things and the second writ petition is a consequence of that.
That, okay, my writ
This-
petition,
this
if
is
the
my
authority
humble
concerned will,
understanding.
my lord, this my writ petition, if your lordship
When
delegate
the
the,
writ petition which was filed before your lordship in 2015,
Yes.
all the points over there
yes,
have already been with annexures are being dealt with in the order which has just now been dictated by lordship. Second, what you have placed is an entirely different subject. Okay, you have said with pakka structure, this, that, which we have also clarified in our reply.
then I have no case, my lord,
Yes,
decide.
yes, you have no case. That's what I'm
Decide,
saying.
court
have
can
no
decide,
case,
you
no
can submit everything, you can submit everything, but I expect from,
Everything.
I expect from the justice. I am not, this is not the justice, dismiss for default is not the final order.
Make a recalling application.
That is not required. Law does not permit me. I have to file a recall application.
You will go and make a fresh writ petition.
So this law does not permit the substituted the illegal has the right. If the initial order is bad, the court cannot shut the eyes. Court will hear the court because of the my father filed the writ petition dismissed for default. Admittedly,
I forget everything.
Everything.
Dismiss for default and everything.
Lord,
You show me a single point
lordships.
in the merit of your case. A
Best
single point.
only single point is this, my lords.
The back end land.
Back in line. This is only point. I have no case.
Yes.
Lordship decide.
I will decide the issue.
Lordships.
Very good. Please take down.
Take into account the paragraph 21.
Yes.
The submission which we made,
Let's decide.
we will see, it's.
Now, my lord, that is the issue of on merit. They cannot say later on that matter is dismissed for default.
আরে বাপরে বাপ,
ওটাই ওই পয়েন্টটা করলে তার মেরিটে হয়ে যাচ্ছে,
তাহলে পঙ্কজ অনেক হয়ে গেছে, লেটস স্টপ,
ওটাই ডিসাইড হয়ে যাচ্ছে অন মেরিট।
চলো বসে যাও।
আলাদা, একদম সেপারেট। Second, petitioner's father, namely Vivekananda Bose, was a proprietor of 21 Chetla Central Road, Calcutta 27. Full stop. Said Paramananda Bose has submitted their statement according to the provisions of Section 6 of Urban Land within bracket Sealing and Regulation Act 1976 with the authority. হ্যাঁ, আচ্ছা 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 আচ্ছা, তাহলে এটা প্রথম থেকে নিন। এটা প্রথম, না না, এই প্রথম এটা পুরোটাই দিচ্ছি নাকি? এটা পুরোটাই এনাকে দিচ্ছি, ওটা কমপ্লিট। হ্যাঁ, এনাকে দিচ্ছি। আইটেম নাম্বার 12, petitioner's father, item 12, namely Paramananda Bose. Paramananda Bose was absolute owner of the premises number 21 Chetla Central Road, Calcutta 27. Full stop. He submitted a return under Section 6 of Urban Land within bracket Sealing and Regulation bracket close Act 1976 before the competent authority. Full stop. The competent authority has prepared a draft statement under Section 8 within bracket 1 of the said Act and served upon Paramananda Bose. Said Paramananda Bose raised objection under Section 8 within bracket 3 of the said Act before the authority. Full stop. On such objection, a hearing was done by the competent authority, whereby by an order dated 23rd of July 1980, the competent authority has held that Paramananda Bose has held an excess land measuring 2011.82 square meter. 2011.82 square meter. Sorry, ভুল বললাম, 2524. কি বললাম? The Paramananda Bose held an area exceed the ceiling limit of vacant land measuring 2524.60 square meter. 2524.60 square meter. Full stop. Against such order, the said Paramananda Bose preferred a writ petition, thereby, on the direction of the writ court, an appeal has been preferred under section 33 of the said Act 1976. The appellate authority has heard the petition, has heard the Paramananda Bose and disposed of the appeal by passing an order dated 16th of November 1988. Thereby, it has been ordered by the appellate court that an area of 802.96 square meter of excess vacant land at premises at 21 Chetla Road is held by Paramananda Bose. Full stop. Thereafter, the competent authority had proceeded to issue final statement under section 9 of the said Act. Paramananda Bose, father of the petitioner, challenged the said order passed by the appellate authority as well as the statement under section 9 of the competent authority, preferred a writ petition being WP number 1504 of 99. 4 of 99. Full stop. During the pendency of the said writ petition, a coordinate bench of this court has dismissed the writ petition for default by an order dated September 21, 2003. As no one appeared on behalf of the petitioner on the date of hearing. Not 2023. अच्छा, sorry, 2023 बोला, 2003 को 2003. It is the case of the petitioner that the father of the petitioner, Paramananda Bose, executed deed of gift in favor of Fighters Lodging Syndicate Private Limited through a registered deed of sale. It is the contention of the petitioner that the order passed by the appellate authority in appeal case number under section 33 of said Act, in appeal case number 47 of 1981 under section 33 of the said Act is illegal and required to be set aside. Full stop. Learned counsel appearing on behalf of the state authority submits that there are no reasons by this court to entertain the writ petition filed on behalf of the petitioner. Full stop. After after so long period, after a long period of time of passing the order of the appellate court, after a long period of time, after a long period of time, full stop. He further submits that the order was passed in the year 1988 and it has been now challenged in the year 2024. Full stop. He further submits that the father of the petitioner, though challenged the order by filing a writ petition being 1504 of 1999, but it was dismissed for default. It was dismissed for default without setting aside or recalling the order of dismissal This court cannot entertain the petitioner. Full stop. Having heard the learned counsel for the parties, it appears that the order of appellate authority passed under section 33 of the said Act 1976 is under challenge by the petitioner in the year 2024. Truly speaking, I find no merit or pleadings in the writ petition to justify how the petitioner came after so long time before this court to challenge the order passed by a competent authority under section 33 of the said Act. Learned counsel for the petitioner submits that if the petitioner was withdrawn from if the petition was thrown out from this court, he would be non-suited. Full stop. Considering the submission, I proceeded to hear the petitioner. Full stop. The petitioner, the merit of the petitioner to challenge the order of the appellate authority is that the appellate authority has not considered the definition of vacant land as enumerated under section 2, section 2 within bracket Q of the said Act 1976. Full stop. It is the contention of the petitioner that at the time of making objection, his father has submitted that there was a structure over the vacant land, over the land in question. Thus, the said land cannot be said to be a vacant land. Full stop. The definition of vacant land is set out as follows. It is set out for me. Q থেকে Q থেকে Q 1, 2, 3 are provided করে আমি একটু মার্ক করছি After perusal of the observation of the competent authority in the first instance, it appears that during local inquiry, some temporary structure measuring 10 square meter was located by the competent authority. It was observed by the competent authority the said structure was constructed without any approval of the Calcutta Corporation. Thus, said structure can be termed as a vacant land. Full stop. The father of the petitioner has initially raised objection that the said vacant land comprising the temporary structure, bracket close, bracket লিখুন, comprising the temporary structure belongs to premises number 19 Chetla Central Road. However, the competent authority in the first instance has observed that the said portion belongs to the father of the petitioner within the appertains to premises 21 Chetla Central Road. Full stop. During the appeal, the father of the petitioner never challenged such finding. Only the area of vacant land was in question. However, after hearing the parties, the appellate authority has considered the submissions of the father of the petitioner and has held that only 802.96 square meter, 0.96 square meter of excess vacant land is within at the premises at 21 Chetla Central Road. Full stop. So it appears that the issue which was not raised by the father of the petitioner during the appeal, now the present petitioner, being the son of the appellant, has raised. I make it abundantly clear that when one issue was not raised or challenged in the appeal, cannot be challenged in the latter stage. Not raised or challenged in the appeal cannot be raised further in the latter stage. On that score, the merit as argued by the learned counsel for the petitioner is not tenable in the eye of law. Accordingly, I find no justification to entertain the writ petition. According the instant writ petition be disposed of as meritless. As meritless. It is true.
আমার বইটা দিন এটা আছে
At all. Both. এই যে না দিয়ে দিন ওনাদের দিয়ে দিন শেষ করেছে দিয়ে দিন
ওইটা না এটা নয় আচ্ছা তার মানে
যেটা বলেছিলাম ভ্যাকেন্ট ল্যান্ড এটা নিয়ে যান ওকে কল নেক্সট ম্যাটার
Grateful, your lordship.
ওকে হয়ে গেল
13 I am but I appear for the petition. I am the respondent KMB. But the point involved is very short. The mother of the petitioner was initially allotted by the respondent
54 square meters of plot of land with a core house. Subsequently, that was allotted in the name of the petitioner before your lordship. Now,
Now,
after
it given 55 square meter
54 square meters of plot of land in Vaishnav Bhata Patuli area.
or given for leasehold right.
Yes, for the mother of the petitioner.
Yes.
Subsequently, it was transferred in the name of the petitioner before your lordship. That was accepted by the respondent, and on various occasions there was communication between the parties. Now, the petitioner before your lordship on 4 occasions approached the authorities by writing the how to make the payment and whom to pay, but all remained silent. Nothing was heard from the respondent. One fine morning, a notice was served upon the petitioner before your lordship that the allotment has been cancelled. Against that, the petitioner has come up before your lordship. Now, we have exchanged the affidavits amongst ourselves, but now what I find, subject to my lord's kind sanction, your lordship will kindly relegate the matter to the authority concerned to give an opportunity of hearing whether the petitioner is entitled to have any allotment in some other place or not. Because in my humble submission, he has not disqualified himself. But on 4 occasions, when he approached the authority to let him know how to pay the balance amount of money, that was not answered. That does not make the
So
petition.
whether it was cancelled due to the balance sum of money.
Yes. Yes, nothing else. So, in my humble and respectful submission before your lordship, it did not make him disqualified for any other opportunity. Now, subject to my lord's kind sanction, it may be relegated to the authority concerned to give him an opportunity of hearing by treating this writ petition as a representation.
Yes, what
Lord,
is your submission?
My lord, unfortunately, I cannot concede to such prayer. Since affidavit has been filed by the authority, and to represent the authority, my lord, my learned friend also knows the difficulty. Here, what happens? My lord, in 1985, a plot of land was LIG category plot was allotted in favor of one Renu Belarani Shomatta, who was the original allottee. Lordship, I'll refer to the page.
Affidavit in opposition.
Yes. Just
Okay.
at a glance, my lord. And such allotment was made in 1985,
Okay.
subject to the condition that 3 installments, it was mentioned that first installment to be paid within 45 days, second installment within 6 months of that allotment, and third installment within 1 year of an installment. And the balance amount, what would remain the balance amount, that would be paid in 40 equal installments.
Is it transfer?
Transfer, allotment, LIG
Allotment in terms of money.
in terms of money.
So the money has to be paid by certain.
Only up to part payment has been made. Other rest of the amount did not pay. The LOT paid only 3 installments.
Okay.
The rest 40 installments, which was to be paid by the LOT, was not paid.
Okay.
The LOT was also asked by the authority to take possession. She did not come forward to take possession. And also,
Possession was not handed over.
no, lease was not, because LIG plot was allotted on leasehold basis, subject to payment of premium, which was for, since it is an LIG category plot, my lord, the category of people who will be availing this, my lord, they are not so affluent. That is why this installment was made.
Same is going.
Within 1 year, 3 installments some amount, and the rest amount to be paid in 40 installments, giving a larger span. And after payment of 3 installments, the authority asked the LOT to take possession and come and execute lease deed. The original LOT did not come forward. So no possession was not handed over.
lease deed was not executed. So what remains? Only the allotment later. So allotment will be governed by the terms of the allotment. It goes without saying. My lord, then the original allotee died in 1994. Till date, nothing was done. After the death, my lord, this present petitioner files an application before the authority seeking transfer of that allotment in her favor. In response to that request, the authority wrote him, furnish the particulars of allotment and your locus. There was no response initially. Then after some time, my lord, again, this petitioner files similar request before the authority. Then the authority asked him to furnish particulars, and particulars are furnished. Hearing was conducted, and it revealed from records, my lord, the original allotee failed to comply with the terms of allotment. And it was stipulated, if the allotee fails to comply with the terms, the allotment is subjected to cancellation.
Is there any term in the lease deed?
Lease deed was not executed.
Okay, okay.
Possession was not
Allotment
given.
order was there.
Only the allotment later. The
Allotment
terms of
letter
the
was
allotment. Terms of the allotment was not fulfilled by the original allotee. So original allotee did not get possession. Original allotee, in favor of the original allotee, lease deed was not executed. But this petitioner, claiming through the original allotee, seeking transfer of that allotment
in his favor.
in our favor, the authority rejected that prayer. Since the original allotee had, my lord, could not fulfill the terms of allotment, and that right of allotment was not crystallized in favor of the original allotee due to failure to comply with the terms. So the question of transferring that allotment in favor of this petitioner doesn't arise. The decision was laid before the my lord knows that whenever an officer takes, that has to be ratified by the authority, board. That was
Upper
placed-
authority.
Yes, that was placed before the board. Board has taken a decision to cancel. After hearing, the substance of hearing, the materials was placed before the board. Board decided to cancel the allotment. Accordingly, cancellation of allotment was done in terms of, my lord, the allotment later itself.
In terms of the terms of the allotment.
Terms of the allotment. So the petitioner has no locus. So that the authority may consider, if your lordship now, lordship kindly come to the terms, the allotment.
Letter of allotment.
Letter of allotment. Lordship kindly come, page 28 of the petition.
Mr. Talukdar, today we are constant of times.
Yes, that's true. This is the sum and substance. I will be showing some documents. Because if I concede to this prayer, my lord, this will open a floodgate.
I understand.
Let us do it on some other day.
Today, 3:30.
So I understand. Then on Thursday, it will be the first hearing matter as part of subject to my sanction.
Thursday.
So, who are you? You are the. You are
But
the
he was
son of-
given hearing.
No,
You are the son of the
yes,
allotee.
I'm son of the original allotment.
Allotee. So, what are the conditions to allotment of such land to the LIG category of people?
My lord, here it was allotted on leasehold basis. Initial allotment later lays down the terms and conditions to be fulfilled. And the payment of premium is a precondition.
No, I understand. But what is the other conditions? Payment of premium, forget it. Why one person to be considered to be transferred or allotted a plot of land?
So that condition, He cannot even pray for that because allotment letter does not contain that provision. But that stage would come had there been a lease or license.
I understand.
So that
These was not
stage,
executed.
that stage was yet to come. Before that, the LOT died. So what right would flow
Very good.
from that allotment letter? At best, he can get return of the amount
Is
deposited
there
by
any
his
1030
predecessor.
matter in next Thursday?
As part heard first hearing, subject to my lord's kind sanction.
Is there 1030 matter? No.
আরো আছে আমার তুমি থাক না, ওটা ফার্স্ট করতে
1030
বলছি।
করছি।
করুন সেটা আমার
But subject to my lord's kind sanction, the affidavit in reply may be taken on.
Okay.
my opposition is on record.
Yes. Affidavit in reply filed on behalf of the petitioner to the affidavit in opposition on behalf of the respondents be taken on record. Argument on behalf of the parties continues. Let the matter appear in the list on 17th of July 2025, 10:30.
Very, very.
Okay, thank you.
দিদি 11-12-তে আমার নামটা একটু কেএমডি এর হয়ে রেকর্ড করে নেবেন। আগে তো একজন